Who is that cat?
Arty.
You just gonna stare at me?
Oh.
I am rollers. What the hell?
Hey, what's going on, everybody? It is Arty of Arty Corporate Fiction. I forgot the cameras on this side. Happy Friday to all of you. The reason why I moved the camera here was because I noticed a lot of you were pissing and moaning that you couldn't see the cat tree. And Winston, right when I was moving the camera, Winston was in the little cubby hole there, but now he's eating his dinner. So maybe he'll jump back in. Who knows? We'll see. Happy Friday. We're going to be catching up to the rest of the Hillygus hearings. I think I'm now like 2.5 hearings behind. They're raring to go. So I want to get us caught up on all the lore. Because I think they had 2 more hearings that taking place. The car, I'm still waiting on them to call me about. I need to call them about my car because I haven't heard anything from the repair folks. So I'll have to brain check on that. The other big news is that the graphics card came in. I put it through the ringer yesterday and this morning with benchmarks, stress tests, all this stuff, and it's working fine, working solid. So it seems like the culprit really was my old card after all, which kind of pisses me off because it was already a refurbed RMA, and 2.5 months later it gives me the same issue. So do not buy Zotac. If you're a PC nerd or a PC person, do not buy Zotac branded graphics cards because they suck. My replacement is an MSI Supreme, for those of you curious. Here, I can show it to you right there. That's the new card. Looks nice. Running smooth. Doing its job. Doing what a 4090 is supposed to do. Anyhow, we're gonna watch the hearing, but I'm also sorry, I hit the wrong button and it muted me. Is that a tiny monitor? No. It's my all-in-one cooler. Well, it's my all-in-one cooler from NZXT, and it has a little LCD screen that I can customize with GIFs and whatnot. And it has my CPU and GPU temperatures on it. And yes, I have all the RGB, even though I told myself I didn't want to do RGB everything, and I'm doing RGB everything, and I hate it. Anyway, moving on. Playing Fires of Rubicon. I have the volume especially low for you guys. Uh-oh. Oh, really? Oh, no, goddess. Look. If it works for you, it works for you. But my old Zotac 1080 Ti gave me 5 good years of good service. It was reliable, but for whatever reason, their 4090s have been giving me nothing but hell. Moving on. Shut up, Omega. We're gonna play this because we're already way behind. Because I want to get through this hearing and probably the next hearing, and maybe Saturday we'll go through the third hearing, and then we'll be caught up if and when trial begins next week. All right. Anyway, pressing play. Why am I announcing that when it hasn't happened yet, Mandy? Okay.
Because I said so.
Okay, Mandy wants me to announce it, because this is just gonna jinx it. Mandy wants me to announce a 15K celebration stream next Friday, even though I haven't hit 15K yet. But there you go, a 15K celebration stream next Friday. And you know what? If I don't hit 15K by Friday at 7 o'clock, it's gonna be really, really awkward. Okay, really awkward. Moving on. Pressing
Please
play.
come forward, tell us who you are, and I'm going to have
So I think last we left off, we was going to be a sheriff was going to testify as to Hillygus' medical concerns. I think. Last I counted, I'm 35 subs away from 35 subscribers away from 15.
Good morning. Please raise your hand and be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, and help you God? I do.
Thank you. Please have a seat. Deputy, make sure the microphone is green. You can see we're a bit old school there. We have blue books there. You can adjust the microphone. You can grab it. And the key for that is get pretty close. Speak up, and when you're ready, please tell us your name and how you spell your name.
Deborah Marino, Moreno.
Thank you. And what is your position, please, with the Washoe County Sheriff's Office?
I work at the Washoe County Sheriff's Department. I work in the inmate management unit.
Okay. And how long have you had that job, please?
I've been with the Sheriff's Department for 23 years, and I've been in the inmate management unit for almost 20.
And can you describe for us, please, what your job duties and responsibilities are?
Job duties in the inmate management is we basically handle all the inmates that are in custody. We do their housing, their classification levels, any security levels, disciplinary stuff. We also monitor phones, mail, emails, visiting, assist agencies as needed, as well as our own.
Okay. Have you had any direct or indirect interaction with Mr. Hillygus while he's been incarcerated?
Yes, I have.
All right. And has it been moderate, extensive, modest, minor? How much interaction have you had?
I see Mr. Hillygus. When he first came into custody, I saw him twice a month, sometimes more than that, regarding ADA stuff. Recently, in the past 2 times I've gone to see Mr. Hillygus, he has refused to talk to us or talk to me about ADA stuff. Usually in the past, when he has brought ADA stuff to my attention, I have gone to medical and talked to medical, but then Mr. Hillygus is not following what medical is telling him to do.
You mean medical care or treatment?
Yeah, medical care and treatment.
Right. Let's talk about your knowledge or information that's come to you, please, on issues with respect to Mr. Hillygus' interaction with the outside world and those people's ability to potentially harass or attempt to intimidate potential jurors in this case. Do you have any information that would suggest he's doing anything like that, or that people that are in support of him are should be of concern to the court?
I mean, I think the people that Mr. Hillygus is involved with on the outside should be a concern to the courts.
How come?
Mr. Matt Scarlartos sends in emails quite often to several hundreds of people. Mr. Hillygus talks to Matt on a daily basis, and Mr. Hillygus will hear something going on in the jail, and then he elaborates it to be something totally that's not going on in the jail, or puts his own thought process into it, and then he talks to Matt, and then Matt puts his spin on it, and then they're sending in emails about things that are not happening or not going on. I do know that this anonymous jury has been a conversation that Mr. Hillygus has had with Matt, as well as Donna and other people that he talks to on the outside.
Who's Donna?
Thank you. Right up yours for the $5.
Donna is a female that Mr. Hillygus calls and talks to.
Okay, and do you have any concern that she might attempt to influence people in a way that harasses or attempts to intimidate the potential jury pool?
Yes, because I know it's been a conversation of theirs. From what the conversation suggests, they are trying to figure out, like they want to be able to find out the jurors' addresses, phone numbers, emails, where they work, their neighbors, and just regarding the emails that have come out to like the sheriff's department, the DA's office, the judges.
What are those emails like?
I would object to everything that this witness is testifying to, as she's arguing facts not placed into evidence. It's all hearsay, and everything that she has to say is her own opinion, and she's not talked to any of these people, so I would object to this witness, and everything she has to say is there's no facts, there's no emails. I've not been provided any of these emails that she's talking about. This is all her own contrived information through her own mind. This is prejudicial to me, and I would object.
Right, your objection is noted. Please continue.
So the emails Mr. Hillygus is having with these people on the outside, they refer to law enforcement, the DA's office, the judges, as part of the Holocaust, Nazis, sex trafficking. There was a conversation with Mr. Hillygus and Matt and Donna, and I even want to say Kathleen, regarding trying to find out like where these people, these DAs and judges, where they eat stuff, their neighbors, so they can go.
Excuse me 1 second.
I would object again to First Amendment right. I have a right to speak to people on the phone, and I'm not doing anything illegal. I'm talking about my case. I'm talking about my strategy for my defense, and everything that she's saying is fabricated, and there is nothing in writing to support and substantiate what she's talking about.
So here, let me tell you this. Your objection is noted. Sorry, let me say this. Your objection is noted for the record. I will give you a chance under oath, or you swear or affirm to truthfully respond. You can tell me your side of this. You don't have to do it in the form of an objection. Let me hear what she has to say, then I'll hear from you. Go ahead, ma'am.
Your Honor, if I may.
Go ahead.
I would also propose an objection in that we're talking about emails and documents that we don't really have before us.
Well, there have been numerous emails that have been directed to the court that have been not reviewed or not considered, I should say, but they've been filed in this. There are close to half a dozen at least by now.
I understand that, but we don't know that those are the emails that this witness is.
Well, that's why I'm asking her to describe what the emails are.
And I understand that having her, it's not the best evidence, Your Honor, and that's therein lies the problem, is we don't have the ability to do effective cross-examination when we don't have these emails that this witness is talking about. So
That's a fair argument, actually.
Kind of puts us with one hand tied behind our back trying to argue this. And then one more thing, I know Your Honor asked for preliminary.
Hillygus wasn't too wrong in his objection, particularly with the emails. When she's speaking about what was said in emails, that is considered hearsay evidence, because they can't challenge the contents of the email.
Sure.
No, Hillygus does not have co-counsel. This is Hanty's legal counsel.
To the extent everything we're here relates to Mr. Hillygus, it has nothing to do with Mr. Hanty. No, so if Your Honor is inclined to grant anonymous jury, then Your Honor should fight it, because nothing that Mr. Handy has done in this matter would warrant any such action by the court.
You know, it came to the court's attention that Mr. Hanty apparently sent another threatening email to the Washoe County Commission
Ooh.
Just a couple days ago.
Wait, Hanty said that?
The court as well
Ooh.
is aware of several other concerns the court has raised with Mr. Hanty from time to time about the manner in which he's expressing his views on things. They may not be the same concerns that the court has with Mr. Hillygus, but certainly they are of concern to the court. But we'll talk a little bit more about that if we need to shortly.
Thank you.
But your objection is noted that the witness is talking about.
Vintage, think of the Australian $5. If it's proven the defendant has history and ability to threaten the people to jury to be good charge, can you lose your right to jury trial? No. That's why they want, no. That's why they want to potentially put an anonymous jury. Even if the defendant is doing everything he can to mess with the jury, he can't, I really don't think there's a way he can lose his right to a jury trial.
Emails that we don't have them up on the overhead, and so we're not exactly sure which one she's talking about. Okay? Do you remember the line of questioning you were responding to, Ms. Reno?
Yes, you were asking me kind of like the content of the email.
Yes.
So there is an email that went out in conversations as well between Mr. Hillygus and Matt about Jody coming up here to Reno and getting together with Mr. Hanty and going around to places that the judges, DAs frequent, their place of business or where they go to eat or their neighbors, and telling the neighbors that the DA, judges are sex offenders, are corrupt, wasting taxpayers' money, sex trafficking people down at the CARES campus.
Okay. Have you seen these emails yourself?
Yes, I have.
About how many total that are, speak to any of the issues you testified to?
I would say there's probably at least 8 emails that have come in that relate to those issues.
Mr. Steggy, do you have any questions for this witness?
And have you seen any coordination or sort of media angle to this?
Clear the court's a little bit under the weather, did test negative for COVID, and we're wiping down all the areas that people touch on a regular basis, witness station, desks, jury box, and I'm going to mask up here, so I don't want anyone to be concerned that I'm going to make them sick. We're also keeping the window open here, and during recesses we open it wide to get some fresh air. Please continue, Mr. Sticky.
Do you see coordination from Hillygus to the Scarlatos and this other woman to push out these emails?
Yes, he's part of it. They have discussions about it, and they'll tell him, yeah, we're getting ready to send this out, this email out, or this information out. So yes, he's very well aware of it.
Including to legislators, county commission, basically as many email addresses as they can find.
Yes.
And do you see coordination in what you're monitoring with Mr. Hanty?
Yes, there is some of that as well.
And
How so?
Because the emails that Mr. Hanty sends into the jail has all their names attached to it as well. And there's been conversation that Matt has had with Mr. Hillygus that, that things are being sent out on his behalf.
We continue.
and that those, what about sort of like something big coming or a plan for disruption of this trial?
Yes,
Hey, Steve Bear.
there was something that was supposed to be sent to you last week, Judge Breslow. I don't know if you received it or not. I think it was some type of an email. And then just last night, Mr. Hillygus had talked to Catherine, and she was telling him to cite the Texas site that he just cited a few minutes ago in front of the jurors, so that the jurors would be curious as to know what Mr. Hillygus was referring to, and they would look that up. And she basically told Mr. Hillygus to ignore what you had to say.
And you just heard in the objection, Mr. Hillygus mentioned that as a strategy, he would like to engage in other types of juror misconduct nullification.
Yes,
And is that consistent with what you have been monitoring with Roger Hillygus?
yes it is.
And broadly speaking, is it fair to describe that Mr. Hillygus appears not to believe in the rule of law or the authority of this court?
Objection, Your Honor, it's fine on that, and it would be a lack of relevance as well.
It's incredibly relevant.
That's a little bit of argument as opposed to a fact question. Go ahead, I'll sustain the objection. You can ask it another way.
In your monitoring of the communications of Mr. Hillygus, does he believe in the authority of this court?
No, he does not.
Judge, you want to speak of the medical portion of this?
Well, only if Mr. Hillygus, if we go up there, we seal this. We're going to talk about his medical care and condition. That's sensitive stuff. So he can either waive that and let us go forward, but I'm going to shut down any reporting on this and direct people not essential to this hearing to step outside.
Well, and as I sort of see it, the court sort of put the burden on the defendant. If he wants to appear in a wheelchair, he must do it himself, or he must bear that burden of persuasion for the court.
True. Or are you thinking how to proceed, or you want me to make a decision here?
I think I'll leave that medical issue
Okay, to him.
to decide at the moment. I wonder if you can just say in general, have there been other efforts or other conversations by Mr. Hillygus to delay or disrupt these proceedings?
Yes, last week he was supposed to go to court, and Matt told him on the phone it wasn't a good thing for him to go to court. Matt's specific words were to lay low for the court on last Wednesday and to lay low for court on Monday. And he even referred to Mr. Hillygus as trying to go to the, in quotes, the H, which was referring to the hospital.
Right, to sort of try to go to the hospital as a tactic to avoid money.
Yes.
Thank you, Judge.
Mr. Silverberg, you made a question, Ms. Marino.
Thank you. These emails that you're referring to, what do you do with those when you read them?
Actually, they come in, were sent into our, at that time, our Captain Caldwell, and so they were forwarded to our office. They get printed up and put into Mr. Hillygus' file.
And is that where they stay?
Yes.
They're not provided to the state?
Some of the emails I have forwarded to Investigator McVickers.
So you had emails that you had not provided though, is that correct? That are relevant to this hearing?
Provided to
To the state, to the court, to Mr. Hillygus, to me?
well, there's like a list of like 100 people on there, and I'm not sure whether the state, the DA's office gets all the emails, because there's just 100 different people that are listed on those emails, and I don't know if they all work for Judge Breslow or they work for whomever. They're just forwarded to our department so that we can put those in his file.
So you have a file on Mr. Hillygus?
We have a file on every email.
Okay. In Mr. Hillygus' file, there's all kind of emails. What else is in his file?
Behavioral stuff, if there's been any behavioral issues, his classification, questionnaires, things to that sort.
And you've read these emails?
Yes.
You've read every email?
Yes.
So my question is, in those emails, has there been any threat to potential client or threat to a juror?
Not a juror per se, no.
And there's nothing wrong with this, with any inmate communicating, certainly pursuing, with whatever limitations the court may place, but there's nothing improper about him communicating with Mr. Scarlatus or any other number of people, correct?
No, there's not.
Thank you.
Mr. Hillygus, you can ask some questions of Ms. Marino, based on the testimony she's given. Statements about the strength of the case against you, the ultimate determination, the motivation of those prosecuting you, things like that. We're not here to talk about that. We're here to ask this Mrs. Marino, who you apparently dealt with, if she has any factual basis relevant to the issue of an anonymous jury.
Can you explain to the court your background and training in the legal profession? Are you
Oh,
a
no.
lawyer? Can you explain about your legal training?
No, I'm not a lawyer.
Are you medically trained? What's your background? Are you a doctor? Are you have any licenses for medical care?
No, I'm not a doctor.
So do I have a First Amendment right? Do you believe that I have a First Amendment right to speak to people on the phone about this government, this court, this way that this is being handled? Is that illegal?
No,
Is anything that you reviewed illegal that I'm doing?
no,
If it
I would
was,
object
I
to
be
that.
charged with criminal crimes for what I'm talking to people on the phone about?
Well, that's make an argument to me in the form of a question. So
I would have objected to the previous question, calling for a legal conclusion.
you don't have to answer that question. But
You claim that you have a,
But hold on. Your point is, to me, Judge, I haven't been charged with any crimes based on my communications with outside people. Is that the point you're trying to establish?
that is the point I'm trying to.
All right,
establish.
understood. What else can we ask Mrs. Marino about?
So you have a file on me of all my emails, and you're providing those to the prosecution, is that correct?
I'm not providing all the emails now.
Are you providing emails of mine to the prosecution?
Yes, I have provided a few emails, but they also have, the investigators also have access to the emails.
How many of those have you provided to me?
Hold on.
Objection relevant.
Yeah, that question doesn't make sense. So here's what I heard her say. And tell me if I have that right or wrong, Ms. Marino. About 6 to 8, you have forwarded on to the investigator, perhaps, or?
Yes, because I'm referencing it in an email, so I just want him to have that. But the investigators with the DA's office, they already have access to the system, so I'm not providing them with anything that they can't access themselves. It's just if I'm referencing it in an email, I want it to all make sense.
All right, so really the question is why those 6 or 8, not the other 100? Are those, did you find something unusual or concerning about any of those 6 to 8?
A couple of emails, just what Mr. Hillygus was going to be attempting to try to do with not showing up to court. The email with Jody coming up here to
Should be working now.
with Mr. Hanty to go around and find where these DAs and judges hang out to harass them, to tell the neighbors things about them.
Okay. Any other questions, Mr. Hillygus?
So I do have some more questions.
Go ahead.
How many total emails are there in the file?
I don't know how many total email, altogether emails, no, I don't know how many total email.
Hold on. So is it fair to say there are hundreds? Mr. Hillygus' file?
Not every email gets printed up, it's on a system that can be printed up. I wouldn't say there's hundreds of emails in his file, no.
Okay.
Can you tell me if there's been at least 200 sent just to one person?
You do send out a lot of emails. To what extent, how many emails have gone out? No, I can't say there's been 200 emails to one person.
All right.
Are we talking about emails that I'm sending out, or are these emails that people are sending in to me?
They're both.
Okay.
The only way you would be able to know how many exact emails you sent out and how many emails came in, you'd have to hand count every single email to figure that out.
Is that something that you could do, like today?
Well, I'm not having her do that, but
But we're talking about hundreds, if not thousands of emails between people sending them to me and me sending them out. And she's talking about 6.
she said 6 to 8, but here's the
So
thing. that-
what's amazing to me is how many people are spending so many hours reviewing my emails, and all I'm trying to do is defend myself, and I'm not putting out anything illegal. In fact, I'm putting out a lot of facts that that's not being talked about. So everything that they're talking about is prejudicial to me because I'm not doing anything illegal. I have a First Amendment right to freedom of speech to talk about what's happening with the prosecution
Mr. Hillygus,
and this court.
I understand where you're coming from, but, even one email that potentially gives the court concern that jurors could be harassed or intimidated could be enough to tip the scales here. That's why we're having this hearing. So let me start over. Final question, if any, from the prosecutor, and final question, if any, from Mr. Silverberg, based on anything they've heard, and then final question from Mr. Hillygus. Mr. Sticky, anything else from Mr. Reno?
Thank you, no.
All right,
I
Mr.
just have
Silverberg.
one other question.
Go right ahead.
How is it that you're here? Who requested your appearance?
Well, I ordered in that omnibus order I sent out.
The judge.
And relevance.
I understand, I wanted, how is it communicated to you? How is
Objection,
it-
relevance.
Hold on a second. Like, is the objection like she shouldn't have to answer who told her to be here?
Well, does it matter to the court who told her to be here today?
It does not. So the objection is sustained. All right, anything else, Mr. Hillygus?
I would actually.
Conspiracy.
I mean,
Go ahead.
on the record, thank
Sure.
you. I think it is relevant, in this matter to know who it is. We've got a file on Mr. Hillygus that he hasn't seen, and now we have Mr. Romero here. Thank you for your appearance. Just want to know how that was communicated to her, and how is it that she's here?
Say, the objection, the court's decision stands. Thank you. Mr. Hillygus, any final questions, fact-based questions here that can inform the court's decision?
I would object to all of her testimony, and I request that it be stricken from this record because
Stricken.
she's arguing facts that have not been placed in evidence. I have not seen or been provided with a copy of what she's talking about, and I do request that I be provided with all the paper copies of every email I have sent and has been sent in to me so that I can use those as evidence in this forthcoming trial.
Okay, thank you. Ms. Marino, you may step down. Thank you for your testimony. I'll give you 1 minute to summarize your position now that we've heard from the witness. Then I'm going to take a short break and come back and decide whether there will be an anonymous jury or not. Mr. Steggy.
The court previously offered Mr. Hillygus the opportunity to.
You're right. I beg your pardon. Thank you for reminding me. So, Mr. Hillygus, there are points you want to establish here. If you want to inform the court on these issues we talked about, I've already told you there's no evidence that either of you were involved in organized crime. That's not a concern of the court for anonymous jury. The issues that we're really here to discuss are 2 through 5, the non-exhaustive list of factors courts look at in deciding anonymous jury. If you have facts you want to testify to, then I'm going to place you under oath and you can explain to me your view of things. I'll take that into consideration. Then I'll let everyone sum up their position. Then I'm going to take a recess. Would you like to be heard? If the answer is yes, I'm going to have you take an oath or swear to tell the truth. Swear or affirm that what you'll do is tell the truth.
And you should also know, Your Honor, excuse me, that he would be subject to cross-examination.
Of course.
I don't need to put anything on the record at this time. I think I've gotten quite a bit.
I have not seen that.
That this court is, has quite a bit to look at and before it wants to move forward. And I will say that I was tested by a medical doctor today. I was hypertensive. I was tachycardic. I am on muscle relaxers. I am having dizzy spells.
My dude has everything.
The medical.
He's got all the ailments.
For my neurological condition. So that needs to be on the record.
Okay, got it. And if I have you swear or affirm, if I have you confirm that what you just told me is made under penalty of perjury, you're willing to do that?
Absolutely.
All right, please raise your right hand. Do you swear or affirm that what you just told the court with respect to your medical condition is the truth, the whole truth, and nothing but the truth?
Yes, it is.
Thank you. You may put your hand down. Mr. Steggy, you may summarize your view with respect at this point to the anonymous jury.
The case was made today for it. I think it's clear that from the testimony of Ms. Moreno that defendant Hillygus does not respect the authority of this court. He's made that clear at virtually every hearing in this case. Mr. Hillygus, although acting as his own counsel in this case, is not a lawyer. He's not bound by the rules of ethics like Mr. Silverberg and myself are. There is great danger. In fact, there's discussion of plans to disrupt this case. I want to underscore this question of whether it's merely protected speech. Of course, it is not. Not all speech is protected speech in this instance.
True.
207-337, simulation of summons, complaint, or other legal documents. The crime he's charged with in this case, one of the crimes is these bogus or simulated legal documents. It's in the court record that they are coordinating to send these fake notices, bogus liens.
True.
It's,
So they are doing putting all these liens on them.
Really makes the case
Not surprising.
for an anonymous jury, and the really targeted and expansive and harassing nature of these emails. Now, Mr. Silverberg's client, Mr. Hanty, there was just testimony of this coordination between them. In my motion for the gag order, my second motion for the gag order on Mr. Hillygus, I attached emails showing Hanty's coordination in that process. So to that extent, he is sort of tied into that. The court may consider as sort of an intermediate option that the information in unredacted form, to the extent that Hanty is really, the court believes Hanty's not sort of connected to this, although plenty of evidence to the contrary, that Mr. Silverberg alone have access to it if there's some distinction to be drawn between the two, that's Mr. Silverberg had access to it, but not his client, Mr. Hanty. Overall, I think the better course is that it be anonymous across the board to all of the parties here.
Thank you. Mr. Silverberg.
Well, I don't think, Your Honor, thank you. I don't think any case has been made regarding Mr. Hanty that would implicate the 5 factors that we've discussed that would support the granting of an anonymous jury. There's just nothing there with Mr. Hanty. He talks a lot, and Your Honor has had discussions with him about that, and he's been sanctioned for that. And I think that is sufficient. I think Your Honor really needs to look at the effect this would have on Mr. Hanty's presumption of innocence. You know, all of a sudden, if Your Honor thinks that Mr. Hillygus, that it should apply to him, I don't, but I'm not Mr. Hillygus' lawyer. But I don't think it should apply to him either. I don't think the factors are met. But they're certainly not met as to Mr. Hanty. So he's left in Mr. Hanty would be left in a very untenable position where he is having this anonymous jury wondering why is it anonymous? He must be some real bad actor. I just don't understand it.
But do you think that the evidence that walks in makes that connection, that there's something unusual? I guess maybe if they've had prior jury service.
Well, Your Honor, and I looked at I didn't just make that up. It's a concern that's raised by the courts. It's
Sure.
right there in the Shrya decision that I cited.
Well, we have to, in ordering an anonymous jury, after finding factors, would support the finding, the court has to take steps to minimize any adverse effect that it would have on the accused and their fundamental rights. And so,
I don't know how we get around that other than bifurcation. Frankly, if Your Honor thinks that there's been that strong of a case made as Mr. Hillygus, then the only course I think would be to bifurcate, because that case has not been made as to Mr. Hanty, and he should not be prejudiced on that basis. And I think the prejudice is real. That's why the courts are talking about it. They say we are mindful of the effect this might have on on the presumption of innocence. They're really concerned about it, and that's why it's such a high bar.
Thank you. Mr. Hillygus, any final thoughts before the court takes a recess?
Yeah, I would like to object to Stagey talking about simulated documents. I know that he doesn't have any training in the law. Because those documents cited all the authorities from the Nevada Revised Statutes to the Nevada Rules of Civil Procedure to case law from Supreme Court of the United States to many other authorities that I'm not able to pull up at this moment. But those documents were absolutely First Amendment rights.
Oh my! It doesn't matter. It doesn't matter whether they were that. Oh my God! He's trying to say that he had a First Amendment right to make these false documents that he's being charged with. No. By his logic, anybody should be allowed, if he did what he did. Let me preface that. If he did what he's accused of doing, gotta put that caveat in there, then by his logic, anybody should be allowed to create their own, I don't know, a DOD document. Like, I don't know, like a false tax return, right? And submit it and do whatever they want with it. That's what he's trying to say. But the problem that he's doing is like basically he's saying that forger, or like I was about to say a DD-214. Like he's allowed to forge. He should be allowed to forge documents because it's his First Amendment right of expression of his speech. Nice, Jack. Welcome.
Actually filed in the court. That nobody was harmed by those documents. They aren't simulated by any means. It was an affidavit, there was a declaration, there was notices. They were absolutely not simulated. That was an assembly bill that wasn't even passed and signed by the governor until July. Some of the documents that they're claiming are simulated were created prior to that, so that's ex post facto. So they cannot go out.
Now that might be something for him there. If he can make the claim that the documents that's being claimed to have been simulated, right? That if they were not prohibited by law until after he was charged, then he might have a case. But this is Hillygus we're talking about. Who knows if what he's saying is true.
After documents that were created prior to the law, the legislature created some assembly bill, Assembly Bill 15, that talks about simulated documents. They're absolutely not simulated. They were legal documents. They're constitutional and have a First Amendment right for those. So I would object to him talking about what he doesn't understand the law, because he's not trained in the law. He's trained in statutes and codes, which are not law.
All right, court, thank you. The court will be in recess for.
Can't I make any fake documents as long as I don't try to pass them as authentic? That is actually a good question, Jake. I think in some states you do need that extra element. You might be right, Jake, that it might be possible that you may not fulfill all the elements, because I do believe an element has to be presenting the document as though it were authentic. Much like in the same instance as DeWitt. You know how Jeremy DeWitt would say, it's not enough that he looks like a police officer. He has to an added element under the statute is that he has to act in the authority of, or cause somebody to take an action as though he were an actual a police officer. So it could be that in that situation where Yeah, if I go to my if I you know, make a make my own tax return, my own 1099, and I just make it and I don't do anything with it, it's just sitting on my desktop, then I don't think I could be charged with that.
Approximately 15 minutes, we'll come back and move forward.
All rise. This court is again in session.
Thank you, please be seated. Mr. Hillygus, did you get a copy of the Nevada Rules of Criminal Practice? Deputy has it right there. All right. Mr. Hillygus, there's a copy for you that the court had printed out. You can take that back with you. I'm sorry you're having difficulty getting a copy for your review. The prosecutor believes, and the court understands it was available
That could be true.
electronically, but now you have a printed copy for.
That is also true. With counterfeit currency might be a different animal. That is true. You may simply being in possession of counterfeit currency could get you in trouble.
Your use. This case will proceed with an anonymous jury.
Oh, wow. Oh, so he's approving it. Wow. Interesting.
Here's why.
Why?
The court does find that there is a strong reason to conclude that it is necessary to enable this jury to perform its fact-finding function and to ensure undue harassment, annoyance, or safety. First, let me talk about the reasonable safeguards that the court intends to utilize here to protect the accused, to protect all sides from any adverse inference. First, the town that the people live in will be not redacted. Their zip code will not be redacted. Their age will not be redacted. Whether they have ever been convicted of a felony will not be redacted.
That's fair.
The nature of the work of any spouse, not redacted. Whether they have children, and if so, what ages, will not be redacted. Any notification as to their inability to serve, because, for example, they've indicated they have a medical issue, mental health issue.
Makes sense.
Extreme inconvenience, undue hardship, travel plans, strong feelings, any other information that would ordinarily be identified on their handwritten or electronically filed questionnaires will remain. But their name, their street address, their social security number, their email address, any other identifying information will be redacted. The court intends to ask detailed questions of each of these respective jurors to compensate in some way for the lack of specificity on the actual veneers. Also, this is equal on both sides here. It's redacted as to the defense and of course redacted as to the state. No one has a chance to go online and look these people up. No one has a chance to run criminal justice histories or be presented with a copy of criminal justice histories by the state from a database that it alone has access to. This court intends to often and regularly and often remind the jury as to the significance of the presumption of innocence at all stages of the case. There will be no discussion by the court or anyone else as to why this jury is being conducted anonymously. The state is ordered not to bring it up. The defense counsel and defendants are ordered not to bring it up. And their respective witnesses, of course, are to be instructed not to mention it. So the court finds these safeguards to be reasonable, to make sure that an anonymous jury does not unduly infringe on the right of the defendants to have a fair and impartial jury. Now, what is the basis for the court's determination? Again, I've said this twice, I'll say it now a third time. There's no indication that this case has any organized crime impact or relationship, so that's a non-issue. It does not favor an anonymous jury. Defendant's participation in a group with capacity to harm jurors. And again, it's not just physical harm, it's to harm them by harassing. And that's been established in the court's mind. There have been, through the course of the proceedings, not just today, but over the last year, several different concerns expressed in email form, in telephone form, and communications by those accused here with people that have the ability to cause chaos. The court incorporates the prior hearings, the prior email sent, the court record in both Mr. Hillygus and Mr. Handy's case. And it's not just Mr. Hillygus's actions alone. Mr. Hanty has been used extreme rhetoric, both in person and hearings with the Washington County Commission, and also in his emails as recently as just last week. That's of concern to the court.
Yeah, I will say that Hanty's not innocent in all this that would warrant a anonymous jury. Even though he's represented by counsel, he said his own level of crazy to warrant an anonymous jury to be applied to him as well, not just Hillygus.
Past attempts to interfere with judicial process or witnesses. I don't have any direct information. There's been efforts to interfere with witnesses, but the judicial process is not lost on the court that at least one email that's on file in this case suggests that a group of people are aware of where the Washington County District Attorney lives. That's not cool.
Not cool, bro. Not cool.
That's concerning. Next factor, defendant's potential lengthy incarceration if convicted. Now, let's understand what that means here. At the time, the court conducted Ferretta canvasses of both Mr. Hillygus and Mr. Hanty. We discussed the charges here and the potential maximum sentence, as I recall. As to Mr. Hillygus, he's facing 7 counts. The first 3 counts of being conspiracy to commit second-degree kidnapping, the second count being burglary, the third count, second-degree kidnapping of an older or vulnerable person. If Mr. Hillygus was convicted of all 3 of those, and if the court in its discretion decided to run the maximum sentences consecutively, that could be as much as 51 years.
Jake, it's the Republic of Texas.
And then the additional, and that actually that's as to both defendants, 51 years for counts 1, 2, and 3. And then as to Mr. Hillygus alone, counts Roman numerals 4 through 7, prepare or delivery of simulated legal documents, that's potential 16. So as I discussed with Mr. Hillygus before he determined to represent himself, 67 years is the maximum sentence the court understands. 51 for Mr. Hanty. Now, of course, that's just by law the maximum potential sentence. The court, quite obviously, suggests nothing by way of the strength of the evidence or by way of the sentence, if any, to be imposed. But a factor is the potential length of incarceration if convicted. So the potential is great. It's great. And then whether external publicity would enhance the possibility of the jurors being harassed. It would. It would. And I'm fully aware, Mr. Hillygus, neither Mr. Hillygus nor Mr. Hanty have been charged with any crimes associated with their conduct. And I'm well familiar with the First Amendment rights of people to speak their mind even on issues that might be unpopular to some other people. But there are limitations. Mr. Hanty's violated that limitation once and served 3.5 weekends. I don't like the rhetoric that has been associated with this case. I don't like the very strong, potentially concerning language that's been utilized by people associated with these defendants. And the court will not subject the potential jury, men and women, to any type of harassment connected with their service. So for that reason, the court does order an anonymous jury. The jury commissioner's office is to redact consistent with this court's order. I see the jury commissioner herself here, and she'll follow the court's order.
Oh, you bad apple meaty, you've actually met John Falax. He is such an unbelievable tool bag. Yeah, he just sucks. He's one of those otter soft sits hybrids. Yeah, he's a tool.
Wednesday, this court will get an unredacted copy and redacted copies, and hand out the redacted copies.
Yeah, I imagine it is. I imagine it was, Jake. I'm in their Telegram group too.
Noted both by Mr. Hanty and Mr. Hillygus. The court did give some thought to an idea presented by Mr. Stakey that perhaps counsel alone could, but that would unfairly prejudice Mr. Hillygus in the court's estimation. So the court opted not for that. That's the court's decision. Now let's slide over to our Nevada judges. They've asked for permission to be present and video and post the trial. Based on the hearing I had last week, I let all counsel and Mr. Hillygus know I was inclined to allow that unless something happened today that would change the court's mind. In addition, an open question was whether our Nevada judges would be allowed to post it daily.
Granted, they better have granted it.
Who are interested could follow along on a daily basis or would be relegated to having to watch the entirety of the trial after it went forward. The court is inclined to allow it to be posted on a daily basis with directive to all counsel and to Mr. Hillygus to remind witnesses
spoilers.
that the rule of exclusion is invoked. The court on its own initiative does invoke it, and they're not to discuss their testimony with other witnesses or watch the testimony from any days prior. That's the way the court's leaning on that issue. Before I order that, Mr. Stakey, would you like to be heard? And then Mr. Silverberg and Mr. Hillygus. Mr. Stakey.
No, thank you.
All right, Mr. Silverberg. Mr. Hillygus.
I just want to make a record. I object to preserve my.
Oh God, make a record.
Decision for an anonymous jury. It's denying me a fair and impartial trial, and that's an appealable decision, and I just want that preserved for the record.
It's preserved. All right. Then with respect to our Nevada judge's request to video during the trial, that request is granted. As to their request to post it on a daily basis, that too is granted. The court is convinced that they will follow the rules associated and proper with the court proceeding and act respectfully and professionally in the manner in which they conduct themselves. Mr. Hillygus, let me talk to you again. Now, would you like the court to appoint an attorney to represent your interest solely on the issue of medical concerns that you have that might impact your ability to move forward in this case? Because if the answer is no, no is no, off we go. If the answer is yes, I've got to do it quickly and see if I can get them here for Wednesday for a status hearing to see where things are.
I do not need an attorney because I have scheduled an appointment. I am under extreme medical distress. I have been, like I explained earlier, abandoned and left in the sun.
But let me stop you, because here's the thing
I'm
though.
on medication.
If you want me, as the presiding judge in this case, to do something with respect to your status, I need a request. I need a motion. I need a file motion with evidence, maybe a witness here, and we have a hearing, and then I make an informed decision. I heard what you said. You testified under, penalty of perjury that it's true. But for me to take some action over the resistance of the state, I'm going to need you to file something, present something, be ready to go. Because right now we are go launch for trial 1 week from today. All right? Does everyone understand that? We are go launch unless in the review of what you filed last week,
I have shingles.
Unless that causes the court some pause or
I got the
concern,
syphilis.
Putting aside its timeliness, the substance, we are
I
going
sprained
on
my
for Monday.
ankle last night.
Those documents were provided to my public defenders, and they were asked to file those, and they failed to do that. They've also.
Well, you don't have a public defender.
Those documents were provided to the public defender and asked them to file. And
Bone spurs.
so those were timely. They should have been timely. So they provided those to me finally, and those have been filed. But being locked down, being on medication, being unable to communicate, and even though you said that I could communicate with my co-defendant, I'm being locked out of communicating with him. So I'm being denied my due process rights to prepare for trial because I'm not able to discuss anything with my co-defendant. So with my medical condition and appointments scheduled, been approved by injuries that sustained inside the Washoe County Jail, until I'm cleared from a medical physician to proceed, I am not prepared to move forward with trial, and it's a violation of my rights and my due process rights because I'm being locked down and I'm not able to communicate with my co-defendant.
Well, I'm not postponing this trial based on that statement. Even if I'm not, right? We're a week out from trial. You do not have an attorney and you resisted the court appointing you one. You understand the limitations that apply to somebody who's in custody. We've talked about your custody
Sucks to suck.
status and at previous hearings about how I take no pleasure in having you remain in the Washoe County jail. None whatsoever. If there were reasonable ways to ensure that you would remain in this county, had a place to live that's been approved by the court, and had a reasonable bond and wore tracking anklet, you'd be out. But we haven't got there. So
My medical emergency only happened 6 days ago. So I'm under the care of a physician. I'm being isolated and I'm being in solitary confinement in the infirmary, and I'm being cared by nurses 3 times a day and medical doctors. So
Oh my God.
I would object to you not granting me time.
Well, the problem is, Jake, he's already been on the lam once before, so that's also a knock against him.
To recover from my medical injury.
So even just saying it probably isn't going to help him very much, too.
And the ability to be evaluated by a hospital here in Reno that's now approved. They're going to, the county jail.
I honestly don't know. I honestly don't. Look, assuming, if he was in solitary, I have no idea what he did to cause that. I genuinely don't.
And I've been scheduled for an appointment with medical physicians.
all right, Mr. Silverberg, any feelings you'd like to share about how you would have the court approach this underneath the, in light of the circumstances Mr. Hillygus has suggested?
Well, I think he's representing himself. He's made a motion to continue based on his medical condition.
Well, it sounds like he has, right? This is an oral motion to postpone this trial to let him get on top of his medical
So
issues.
here's what I suggest, because he's in a very difficult position where he won't be able to have people here Wednesday, but Your Honor ordered somebody to be here today to talk about the anonymous jury, so I think Your Honor could order somebody from the jail to be here that can talk about Mr. Hillygus' medical. Maybe that's the way to do it, if that's what he wants to do, but Your Honor can certainly order that, and I think in light of the fact.
In fairness, yeah, Hillygus has been in custody for like a year, at least a year, right? I think.
fact that Mr. Hillygus is representing himself.
So he's had a long time to prepare.
And I know that the state and myself are anxious to know whether this is going to go forward or not. There seems to be, it seems to be quite unclear, but I know that we're both desirous of an answer sooner rather than later as we prepare for trial.
Well, it's not unclear in the court's mind. We're going to launch a week from today unless I have evidence to suggest that Mr. Hillygus is not well enough to proceed. So
I think the only way we have that is if Your Honor orders somebody from medical to be here for the hearing on Tuesday. Would that be somebody that I don't know any other way around it. I think it should be heard. I think it's a serious issue as to whether or not Mr. Hillygus is going to be prepared or whether he can prepare. And I'm concerned about whether his lack of ability to prepare is going to affect my representation, Mr. Hillygus.
okay, I understand your position. Mr. Stiggy, your thoughts, please.
I asked the court to slam the door shut today on this issue because many things are in the works for this, and a seed of a possible continuance is quite impalatable to the state. There are people here today. We have brought up this issue of the medical thing in our prior argument and prior testimony. Let's handle this today. Because it's not tenable for the parties to be working like this for then have it continue. That is just simply not tenable. So I propose a hearing be had right now on this issue. There's Mr. Hillygus can offer.
All right, right up yours, Tia.
The court can offer information on this issue, and the court can decide if it's continued or if it's not continued.
Well, I didn't have this scheduled for that. I'm not generally familiar with, I have a basic understanding of what the law is on whether somebody's medically able to proceed to trial, but I haven't reviewed the legal authorities on that lately. I could take, if there's somebody here today from the jail and Mr. Hillygus gives authorization, because if he doesn't, I don't have anything else to go on. But
well, if he doesn't, then there's no motion. We can't.
So if it gives authority for the court to hear it, I guess I could hear the evidence today and then take it under submission and turn around an order within 24 to 48 hours on whether that's sufficient to allow this matter to be postponed or it goes forward. Or I set a hearing Wednesday and we all get geared up for that first thing.
A bitter taste in my mouth if we wait till Wednesday, only because.
Well, we're going to be back here anyway. We're going to be back here marking exhibits. We're going to be back here with the jury veneer redacted. We're going to be back here to go over the witness lists. So, it's not as though we're taking a day off. We're going to be in court Wednesday anyway.
No, but dozens of people are setting up their lives to be able to prepare for testimony.
What if you had a stroke 6 days ago? What if you had a heart attack?
He did it. He was left out in the sun. He's overemphasizing it. He's planning to delay. The medical appointment we will hear is for a minor issue. The wheelchair thing has been a ruse for most of the time that he's doing.
Ooh, okay, Steggy is not mincing words. He is calling Hillygus out on his shenanigans.
So the court needs to hear that and shut the door on it today rather than leave it open for more delay tactics.
Mr. Silverberg, were you?
I suspect that's the evidence.
Were you prepared for that?
I'm not ready for it because I didn't know this was going to be an issue today, other than I heard that Mr. Hillygus might be in the hospital, which I notified the court of the state as soon as I had heard that. I think Mr. Hillygus should have the ability to have the person that could assist him the most in his argument about his medical condition. I don't know if that's the person that's here today. I don't know. But to the extent that he can speak for himself, that he should have the opportunity. I don't know that he anticipated that that person would be here today, or maybe this is the person. I'm not prepared to go forward, but those are the concerns I have.
Okay, Mr. Hillygus, you heard the discussion I had with Mr. Steggy. At some point, if you want me to postpone this trial because your medical condition doesn't allow you to go forward, I'm going to need some evidence to base that decision on. Do you understand that? And it's going to be more than your testimony. I'm going to have to hear from a medical provider, a licensed medical provider, who can speak to that. Now, if that person is here today, I can at least take their testimony and then go research what the law is and decide what to do. If that person is not here today, I can order he or she to be here Wednesday, and I can see everybody at 9:30. We can take it up at that time. over the objection of the state, because they want to know today if we're going to trial or not. What do you think?
So I agree that the medical provider is not here today and that the medical provider does need to be here because that's the person that's evaluating me, that's reviewing my medications, that's reviewing and taking my vital signs, that's talking to me. And so the person that's here today is not the medical provider. And so I will not grant them the ability to speak because they have not been treating me. So the person that needs to treat me needs to be ordered to come here to discuss my care.
Are they an employee of Washington County, or is it somebody coming in from the outside?
It's my understanding that they're a subcontractor for the Washington County Sheriff's Department from NAFCare. And
Okay,
there's,
and if we have this hearing Wednesday morning, are you going to give your okay to allow them to speak to these issues?
if you order the two providers and the medical director, or not the medical director, but the two providers, I guess you could call them, they are licensed medical physicians, I believe. They're the ones that are prescribing me the medications, they're the ones that are ordering my evaluation to be scheduled and approved at the hospital. Those are the people that need to be here, but the person that's here today is not
Not that
treating
person.
me.
Okay. Any final thoughts, Mr. Silverberg?
No, Your Honor, thank you.
Any final thoughts, Mr. Sticky?
The idea it's a surprise is kind of, doesn't make sense because, of course, we heard last week about this issue. Before this court has that full-fledged hearing, right, he ought to be required to make a prima facie case.
Well, I put him under oath before.
Right, and so we know nothing about the medical condition, nothing about, and let's base this in the law, right? Always helpful to come back to the law, right, which is competency.
When in doubt, follow the law.
When in doubt, hey, let's go back to the law, right? And we're not making this on like an equities or like a feelings about Mr. Hillygus. We're basing this on with the law. Now, and so here's how I see it. If he's not competent, that would prevent a trial. We know that from a lot of case law and statutes. Outside of that, it's a discretionary call where the court believes there's good cause for continuance. Now, I don't wish to come back to this, but the parties have a lot in motion on this, on setting this trial up. And for even 2 more days of that effort to go forward and the court continues it, I would wish not to waste that. Of course, I defer to the court's judgment on this, but let's, returning to the law, right? We have no idea what is at issue here. He wants to cause more, the idea that physicians should have to be here on Wednesday. I think that's much too high of an evidentiary standard given the lack of any prima facie case here. Right? If it's competency, you would expect something like he's on PsychNet. I submit the answer to that is no, based on my understanding of the evidence. That he was left outside, and that is debatable. I think we did hear testimony today on the question, his sort of equity-based being left outside. But anyway, the effects of that quite minimal. So it's not competence. I submit there's
Hey, Cerebral Tackle, thank you for the $5.
evidence today. And if there's evidence to be had, let's try to get it today. Otherwise, it's simply a good cause continuance. Now, I'm happy to weigh in on that sort of analysis, but I think history ought to go into that assessment. So I'm against the continuance in the general principle, but I'm most against waiting 2 days and then having it continue.
Uh-oh. I'm coming back to it. Want to take a break.
All right, give me a moment. Mr. Stakey, are you available 11 a.m. tomorrow morning for a hearing
I'll
on
be
this?
available anytime, Judge.
How about Mr. Silverberg?
I do have a docket tomorrow, but I should hopefully be done. Part of it's here, so hopefully it'll be done by then.
Okay. All right, it's the order of the court as follows. That the West County Sheriff's Office used best efforts to secure the attendance tomorrow morning at 11 a.m. for a hearing on Mr. Hillygus' medical condition from the person most knowledgeable about the care he's receiving. So the court can make an informed decision on whether this matter should be postponed. In the event the person's not available tomorrow at 11, then it'll be kicked over to Wednesday, 9:30. But we will try to have this hearing tomorrow at 11 o'clock. So again, the order is that the Washington County Sheriff's Office is directed to reach out to the medical provider that's providing care to Mr. Hillygus, and they have a representative here tomorrow at 11 o'clock to testify under oath with respect to his care or treatment, with respect to his ability to go forward with trial next Monday.
Oh my God.
Waive Mr. Andrews' appearance for that hearing as well.
Yes,
Thank you.
you're welcome.
We print it out and provide it so that I could use those at the hearing tomorrow or Wednesday.
With respect to your medical care?
Yes, absolutely.
All right. So it sounds like they're going to hold a hearing for him.
Last week.
Yes, they are.
About how many are there?
I believe there's 2 or 3 grievances that have been submitted, and I'd like those printed out so that I can use those at the hearing.
Wait, grievances?
Well, that seems reasonable. I'll direct the sheriff to use best efforts to print out and have those available for the hearing tomorrow morning at 11 o'clock, or if the hearing doesn't go forward until Wednesday, then at 9:30. Now, here's the thing. Somebody needs to let us know whether 11 o'clock hearing is go or not. And so let's stay close to our emails to know whether we're going to have this hearing tomorrow or it's going to be Wednesday at 9:30.
All right. We're going to go straight to the medical hearing. All right, let's do it. I think it's this one.
All rise. The Second Judicial District Court, the state of Nevada is now in session. The Honorable Barry Groslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in state of Nevada versus Roger Hillygus and Stuart Hanty. The court has previously excused Mr. Hanty's attendance from this hearing. This is a follow-up to yesterday's hearing where Mr. Hillygus expressed concerns about his health and his ability to proceed to trial starting on Monday. The court deemed his request to be an oral motion to postpone the trial, to continue the trial, to allow him to regain his health so he could go forward. The state strongly objected, indicating that it did not feel that either really a hearing or that substantively the case had been made to justify continuance, indicating the state believed it was a ploy or an act designed to obstruct the administration of justice and not a sincere request to allow Mr. Hillygus to regain health sufficient to move forward. Because the court wanted more information about Mr. Hillygus' health, and because the hearing yesterday was not set up or noticed for that, and to make sure that Mr. Hanty and his counsel as well had time to prepare, the court indicated it would hold a hearing either Wednesday of this week when we were set to be in court anyway, or today if we could manage it, taking into account there are many moving parts in preparing.
How much does this thing cost your government? I mean, you know, depends on where you're at. But you know, depending on people's salaries, you're looking at, you know, at least a couple, well, not at least, probably in the 5 digits. In court's time. I mean, I couldn't tell you per hour, but you know, depending on the per hour salary of the judge, the court staff, the attorneys, you know, it can rack up.
And so the sooner parties knew if this case was going Monday or not, the better. And so we were able to arrange a representative of NAFCARE to be available virtually, somebody with direct knowledge of the care being rendered to and condition of Mr. Hillygus, as well as I understand an administrator, senior administrator from NAFCARE in the Reno area is present in the courtroom today. The reason we're having a remote witness is because the person most knowledgeable, apparently, on Mr. Hillygus' care is out of the state today, and so this was the best alternative to hear from that person. The court recognizes that with a virtual hearing in the courtroom, it's a little awkward because the camera that focuses on the bench I'm now looking at, it's up on the wall, but the monitors where witnesses are shown to the members of the audience, the jury, counsel, the accused, or the court are up on the wall to my behind me on either side, and also I have a monitor here to my left. So that occasionally when a witness is testifying remotely, if I'm looking at a monitor, they'll just see the side of my head. I also would note that both Mr. Hillygus, Mr. Silverberg on behalf of Mr. Arty, and the prosecutor have microphones, and so when you're speaking, put the microphone directly in front of your face. Please make sure it's on and speak loudly so that anyone who's appearing remotely can be heard. All right, so without further ado, I would like to hear from the administrator who's here in court to see who he or she is, what their role is, and if they could please identify themselves and come forward. And I'm going to ask you a few questions under oath. If you would please come forward, raise your right hand, and take oath of witness.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Would you please have a seat at the witness station? I'll ask you some questions, and then I'll let counsel and Mr. Hillygus ask questions. And let me also say this. Before we proceed on issues with respect to Mr. Hillygus's medical care and condition, Mr. Hillygus, you have a right to have this hearing closed, in which case there will be no media presence, and also I could also direct people not directly related to this case to step outside, and I could seal this hearing and make sure that it's not available to people other than those connected with the case. Because
I wanted to bring in Winston, but he's being a fat kitty and still eating his dinner.
May go over and likely will what would otherwise be protected or confidential medical care, condition, and status of yours. I mentioned that yesterday. Have you given thought on how you'd like the court to proceed under those circumstances?
We can proceed as you see fit. I don't need the cameras to be removed from the courtroom, but I would ask that the administrator here has had emails and grievances that you've ordered to be provided to me for today's hearing prior to the hearing.
Well, let's just talk about
She hasn't, but I have not been provided those.
Okay.
But she hasn't.
Okay, we'll get to that in a minute, but in terms of having cameras in court to record what's happening, or audio to record what's happening, are you comfortable having it remain in open court?
Yeah, but part of what will become apparent is through these grievances.
You get chunky boy.
Through the witnesses and through the court. So I those that were ordered to be provided to me prior to this.
The hell is texting me
I've been told she
on
hasn't,
Steam?
and would like to have those before we proceed.
Okay, well, we'll get to that in just a minute. Mr. Stakey, any objection to the court proceeding in open court with a hearing like this?
No.
Any objection, Mr. Silverberg, on behalf of Mr. Henty? All right, so we'll get to the grievances or communications here in a minute. Would you please tell us your name?
Kendra Heft. My professional name is Kendra Heft.
Say it one more time.
My professional name is Kendra Heft.
How do you spell last name?
F is in Frank.
Okay, I'm going to need you to slide in and get the microphone right in front of you, and if I would ask you to please speak up.
Wait, I'm back. OBS crashed again. It's not Comcast. It's OBS. OBS. Blame OBS. I don't know why OBS crashed on me, but it did. We're good. We're good.
In just a moment, to your knowledge, is he licensed to practice medicine in the state of Nevada? And have you worked with him before?
Yes.
Are you confident in his abilities?
Yes.
All right. Now, you heard Mr. Hillygus a moment ago mention something that he believes you might have in your possession or under your custody and control. What he mentioned yesterday in the court order, grievances, but the sheriff indicated it would liberally construe my order to get to the essence of it, to be communications with respect to his health care. Were you aware that that was something the court asked to be produced today?
I was unaware that you asked for me to provide it to him directly.
Okay. Did you give it to somebody else in the sheriff's office?
At the district attorney's office.
All right. Does the DA have that with you? And if so, do you have a copy handy? Mr. Stinney.
I believe I do. It's,
Can I say something? They're not actually medical grievances, though.
Are they grievances? Are they health related?
it looks like it's more of what we've seen a lot in this case, which is people affiliated with sovereign citizens sending an email blast to the entire world, politicians.
He said the word. He said the sovereign citizen word. Object.
Etc., making it very broad and unsubstantiated.
No, I would object. These are emails, they're grievances addressed to the Washoe County facility and detention facility, and they're clearly a medical grievance.
Okay, of a medical nature?
Yes.
It is a process that grievances are sent to the medical staff, that Mr. Hillygus is very familiar with how to send those notices through the smart communication system so that our staff does receive them, and they are labeled grievances, medical grievances, and they are addressed to medical. There have not been any of those in the last few weeks from Mr. Hillygus sent to us.
Well, I'm confused now, because I understood, according to Mr. Hillygus yesterday, there were two, perhaps three grievances of the term he used that I understood bared on his medical care or condition, and I wanted to make sure that if he wanted the court to consider those as part of the decision whether he's able to go forward with this trial, that they would be produced. So, do they exist or do they not exist, and if so, where are they?
He's got them in his hand, but I would like them to be produced because they are medical grievances, but that they were sent as emails, and the reason why is the tablet has a small box and it does not allow to fill in the complete essence of the grievance. So it was sent as an email, and that email was forwarded, and it's addressed to the sheriff's department, it's addressed to all the professionals that are handling my case, and it's clearly addressed as a medical grievance.
All right, so Mr. Steggy let's make sure we're talking about the same thing. Does the witness produce these to the district attorney's office in compliance to her best of her ability with the court order?
I believe so. I don't recall the court order. I don't know why we're here. This is not medical grievance court that we're in.
Well, it has to do with information that Mr. Hillygus wanted to present to the court that may bear on his medical care or condition.
Well, his care is really relevant to this court.
Well, I'll decide what's relevant. It's relevant to the court's decision. What I would like you to do, though, is please approach the witness and ask her if these are the universe of what she recovered and forwarded to you.
Will you please review what we'll shortly mark as Exhibit 1?
Yes.
Thumb through to make sure it's everything being pulled together.
This is what was sent to me by one of Mr. Hillygus' companions that he deemed as his medical grievances, yes.
Okay, well, so these don't come from you, Mr. Hillygus, they come from somebody else on your behalf?
They come from me. I send them as an email because the grievance tablet does not
Doesn't allow
allow
me to describe it in detail.
So I had to send it to someone else and ask them to forward the emails to the Washoe County Sheriff's Department as a grievance.
Please retrieve those from the witness. Let's have these marked as Exhibit 1, but Mr. Hillygus doesn't have...
Wait, hold on. So he sent them out to, so he sent out an email to his colleague. So he sent his grievance to a colleague who then forwarded it to the sheriff's office. Okay. All right, I'm going to slow it down to 1.25.
Copy of these for today's hearing. Let me have a look at them, please. Thank you. Doctor, we're going to get to your testimony here in short order. I appreciate your patience.
You can have my copy, Judge.
Okay, all right. The record should reflect Mr. Hillygus is being provided a copy from Mr. Steggy. So the first email is from Dr. Wade to other people, right?
Yes, I think the court needs to flip a little bit more towards the back from the aforementioned Mr. Scarlatos.
These are not the grievances that I filed with the Washoe County Sheriff's Department.
None of them?
I did not see them. No, I did not. This is the first I've seen of any of this. I don't know what this is. This is something that was sent to Amos Steggy. It was not sent to me, so I would object to any of this being presented as evidence because it has not been provided to me prior to this hearing. I'm not prepared to address any of this. This is not the grievance that I filed. I would ask that this hearing be vacated and that I be allowed to get the grievances that I filed through an email, and I will make sure that they are sent to the Sheriff's Department, and then I can move forward. But I object to all of this as being ambush evidence. I do not know what any of this is. I have not seen this prior.
You haven't seen any of these before?
No.
No, none of these were sent on your direction?
No.
So the 2 or 3 things you mentioned yesterday, none of them are here?
That's correct.
And you've explained to the court that since box is limiting the amount of information you can put in there, at your direction, you had other people send emails.
I sent the email. I typed up the email on the tablet and sent it out and asked them to send it to the Sheriff's Department as a grievance on my behalf. Because it's not effective. The box does not allow for enough information to be
Okay. Well, as to the representative from the Washoe County Jail here,
Raymond, I don't know. I'm like on the fourth mission. I couldn't tell you whether or not. It's fun. It just takes some getting used to the
I
controls.
oversee the medical providers that provide him care specifically. We discuss his care on a weekly basis. In addition to that, I have visited Mr. Hillygus on several occasions to provide him medications, complete assessments, make sure that he was doing well in our facility.
okay, do you have any reason to believe he has not been doing well?
No.
None whatsoever?
No.
Have you heard that he's indicated that he was left out in the sun for 2 hours inappropriately and that caused him duress, discomfort, or adverse medical consequences?
Yes, I have heard that.
Okay, and what do you make of that?
In reviewing video footage and doctor's notes and visiting Mr. Hillygus myself, I believe that.
I would object. I have not seen any of this video footage. This is ambush evidence. Once again, this is
Oh my God.
inappropriate. I object to this hearing moving forward as I have not been provided any of this information, and this is not the information that I was prepared today to address.
All right, your objection is noted. I'm going to go forward, though. Please continue your answer.
I do believe he is in good health that can continue with his process.
Well, why do you say that, though? You've heard some of the, has it been made known to you what some of the concerns are here?
Yes, it has.
All right, and again, what do you make of that?
I believe that he's been provided the adequate medical care that he needs, and that he is receiving the care he needs in order to move forward. That after the incident, or the supposed incident, of being left outside or being outside for an extended period of time, that he received medical care at the facility that was adequate.
Mr. Steggy, any questions of this witness?
Are there any lingering effects from this being left outside incident?
Not that I have noted.
And you're a trained medical professional yourself,
Yes.
in addition to being the administrator over other medical professionals.
Yes, sir.
You meet with the treatment team once a week regarding this defendant.
Yes, I do.
You do that with respect to all defendants.
All of our defendants that need or are requesting medical care from our team.
Among the inmates in the Washington County Jail, is his level of care, isn't it true his level of care is quite low?
The need for care is quite low, yes.
And yet he is, in fact, you were here, the person who was here yesterday when we asked for this hearing, correct?
I was here yesterday, yes.
Okay. And so you were then as knowledgeable as you are today about his conditions.
I would say I'm a little bit more knowledgeable today, as I heard that this was happening and felt the need to make sure I knew his care through and through.
Do you see any barrier to him proceeding to trial or any other type of courtroom
I do
procedure?
not.
Have you, you've noticed a number of objections or obstructionist behavior by the defendant. Is that consistent with the behavior he exhibits?
Well, let me
I would object to it.
first.
The behavior he exhibits while in jail?
All right. I kind of would object to that. I would object to that question, in fairness.
Well, hold on. The objection is that's not relevant to what we're here to talk about today, or?
Yes.
It may be relevant. The objection's overruled. You can answer that.
Oh, come on.
It's true, he's a very demanding patient or inmate.
Yes.
And that's not what was asked.
Oh, he rephrased the question.
He does make requests, yes.
And you've seen in court that he's, one might say, obstructive. Is he the same way in jail?
One might say yes.
And you said you watched the video of this being left outside.
Yes.
And what does it show?
It shows that timelines were a little exaggerated and that he was not out there for the extended time that he states he was.
And what was the medical effect of being left outside?
He felt that he was dehydrated or that he started to have a sunstroke. So we made
I
sure
mean,
to
Woodwork, it's a
monitor
from
and make sure that
soft
he was doing
game.
quite well, and
So-
that those effects were not completely
Yes.
founded, and that they were tended to as he needed them to be.
Okay. Were the effects exaggerated by him?
Yes.
Were anything concerning about his vitals at the time or his medical condition?
Not that's extremely out of the ordinary for him, though.
So we have before the court in this exhibit a note from the doctor indicating that Mr. Hillygus' use of a wheelchair appears to be volitional. You aware of that?
Yes, I am.
What does that word mean?
What does that word mean to you?
More so not medically necessary, more so that it is his request and requirement.
And so are you aware of observations of whether
So performative. He's not demanding the wheelchair out of a medical necessity, but more out of his own personal preference.
in fact that is the case, that he is able to walk but chooses to use a wheelchair?
I have seen situations of such, yes.
Let me ask the witness, can you describe your medical training and experience, please?
I'm an IC nurse by trade, and then a pre-op PACU OR nurse,
Where did you receive your education and training?
Carrington and Chamberlain.
Okay, and how long of a program was that?
Kind of feel like they should have asked about her qualifications from the outset. But yeah.
Your degrees were conferred.
BSN.
Okay, Mr. Stinky, any other questions?
Although the emails that were attached that you reviewed from the compatriots of the defendant, is there any, in your view, of that truth to the allegations contained there?
With respect to medical care or
Yeah,
condition?
mistreatment or intentionally leaving him outside, revenge or something?
Objection. Objection. Requires speculation on the part of somebody that doesn't understand what was written.
Well, the question really is, did she believe there were any factual inaccuracies? So you can ask it that way, or you can respond that way.
I do believe that his statements have quite a bit of inaccuracy.
Jennifer, thank you for the $4.99. I appreciate it.
The time frame that he was left outside, the demand to go to the hospital following the incident, the
Did you go to the
I
hospital?
would object. No, it's not.
I'll let you have an ongoing objection to this line of questioning, Mr. Hillygus. Was he taken to the
There is
hospital?
no video.
no,
And why not?
there was no foundation for him to leave the facility.
Okay. Mr. Steggy, any further questions?
Are there any ongoing chronic conditions that would interfere with the defendant's ability to be in court?
I do not believe so.
Separately, the defendant is claiming their separate grievances. Are you aware of any other separate grievances by him about medical care?
No. The
And,
grievances I received were, or the emails I received from his colleagues, I believed to be the grievances that he was referring to.
and has there ever been an occasion with Mr. Hillygus and his transport to and from court that caused a medical concern for you or your staff?
No.
Thank you, Judge.
Mr. Silverberg, any questions? If you're going to question seated like Mr. Steggy, if you can please slide the microphone a little bit closer to you.
Thank you, Your Honor.
Thank you.
The emails that you provided, were there other emails that you chose not to provide?
No.
These are all the emails that you have in your possession?
That I have in my possession. Those were the only emails that I have received from any of his colleagues.
Okay, so there may be other emails that you didn't receive?
I'm unaware, so I cannot answer that question.
So those are the ones that you have, correct?
The emails I have forwarded, yes, those are the only emails I have.
And you printed out copies of those
I did.
and gave those to the state?
I emailed them to state.
Okay, any reason they were not emailed to anybody else?
I don't have anybody else's email.
Did you talk to anybody else between yesterday's hearing and this hearing about your testimony today?
No.
Thank you.
Mr. Hillygus, you may have some questions related to your care, your treatment, the event from the other day when you were left outside, the information that the witness has discussed here.
I heard that you're qualified as a nurse. Are you qualified to prescribe controlled substances?
No.
Have controlled substances been provided to me?
No.
Am I currently taking medications that have been prescribed by a physician?
Yes.
Upon being booked, was I evaluated by somebody from NAMCARE?
Yes.
Did they determine that I was to be in an ADA cell?
Upon being booked into the facility, no.
Is it not true that a nurse named Janet that works for NAMCARE wrote on a card, on my booking card, that I'm to be in an ADA cell? That I use this card everywhere I move within the facility, and I've been in an ADA cell since I've been there for 8 months?
I'm unaware. I cannot answer that question.
Do I use the shower in the infirmary as an ADA shower?
Yes.
Is that the only ADA shower in the facility?
I believe so. I'm not 100% certain.
Would I be allowed to use the ADA shower if I was not determined?
Movie night tonight. We already watched Rogue One when I was way too drunk. All right,
Is the ADA shower allowed for people that are not?
long time ago.
ADA? Can anybody use that shower?
I'm going to default to that as a custody question.
Can an inmate?
I've done a lot of movie nights, and I'm not very proud of them.
Grab one and use it, or does it have to be ordered and provided?
It needs to be provided.
Are you qualified to do evaluations, and have you evaluated me?
Yes.
Can you explain when that was and what exactly evaluation was performed?
Just a physical assessment, just to see how you were doing. A set of vitals were taken. Conversation was had to ask if you had any medical needs at that time. Mental health needs or dental needs. And an ongoing assessment that we provide for you to make sure that we are providing you all the needs that you are requesting or you feel that you need medically.
On the day that I was left in the sun, you said you watched the video, is that correct?
Yes.
Has that video been provided to me?
I'm unaware that is a custody question.
Has that video been provided to the prosecution?
I am unaware.
Was I evaluated by medical professionals on that day?
Yes,
Can you name who they were?
I can.
Can you name them?
Billy Botany, Rex Weeks.
Are those two people or one?
Oh, and Rex Weeks, as well as a few of our nurses that were there that day.
What was the first name that you mentioned?
Billy Botany,
And what is her title and position?
nurse practitioner.
Is she licensed by the medical board
Yes,
or by the nursing board?
she is a nurse practitioner. She's licensed by the nursing board.
And is the other person that you mentioned, Rex Weeks, is he a licensed physician?
He is a physician's assistant.
Is he licensed by the medical board, physician's board, or by the nursing board?
He is licensed by medical board.
Is he available today?
He is unavailable today.
Is he the one that prescribed me medication?
He has prescribed you medication.
What medications has he prescribed?
Without looking at your chart, I do not have that information at my fingertips.
I was unprepared for this line of questioning with this witness. This is an ambush. Once again, I object to this hearing and to what's occurring here today is completely inappropriate, it's unprofessional, and it's a deprivation of my rights.
Well, I would note that there was an oral motion on the Monday before the Monday of trial, not a written motion for the opportunity for people to respond in writing, but an oral motion to postpone this trial. So the court is moving as quickly and as it reasonably can to bottom this out to the best of its ability.
But if I can't defend myself, if I'm ambushed with emails that aren't proper, if I'm ambushed with witnesses, I'm ambushed with not having been seen the evidence that they're talking about, this is completely unfair, and it's a lack of due process, and it puts me in a position of vulnerability.
Okay, well, what I've heard is that the one piece of evidence is the video that apparently the witness has seen, not the state, as far as I know. The court hasn't seen it, so nobody's seen that. In terms of these emails, I just thumbed through the very first page. I haven't reviewed them. I may not even rely on
Those
them.
aren't the right ones.
I heard you when you said those were the two
I
or
haven't
three.
even seen those until today.
Understood.
I was to get those prior to the hearing, and I did not.
Okay, I understand. Based on the line of questioning just now, Mr. Stady, anything else for Ms. Hoft?
Heft.
Okay, thank you. Sorry if I mispronounced it.
Thank you. Yes, Ms. Heck, yesterday, Mr. Hillygus repeatedly referred to having an appointment with a medical provider at the hospital.
I'm sorry.
Can you
Referred to
sit up and talk to the microphone, please? Thank you.
Yesterday, Mr. Hillygus repeatedly referred to having an appointment off-site somewhere, either the hospital or somewhere else. Are you aware of what that is?
Yes,
What is it?
it's an eval appointment for the need for possible physical therapy.
Thank you.
Mr. Silverberg, any other further questions?
Can you just read what's in physical therapy?
Mr. Hillygus states that he has C7 issues going on in his neck, that he also suffers from a previous traumatic brain injury. And we want to make sure we're providing him the care that he needs in order for him to not have to be forced to utilize the wheelchair that he requests.
You think the wheelchair assistant?
In what nature?
Does it provide him assistance?
It provides assistance.
Do you know how his legs feel?
No.
No.
Mr. Hillygus, anything else based on those questions and those responses?
Not of this witness. I would object to the other witness as not evaluating me but one time, and that was for a fall injury that I sustained in the facility. I do recognize Dr. Wade. I did meet with him. He did order x-rays of me, but he did not recently evaluate me. It's my understanding he's out of Las Vegas, and he has not been at the facility. I haven't seen him but once.
Well, let's hear what he has to say, and then you can argue to the court why I should give it little or no weight as to what we're here to do. Nurse Happens, thank you for your testimony. You may step down.
Thank you.
Thank you. All right, at this time, Dr. Wade, can you hear me okay?
Yes, Your Honor.
All right, thank you. I appreciate your patience. We're going to ask you some questions. Mr. Hillygus is allowing you to respond fully to questions put to you, even in a context of an open court hearing like this. So be aware of that. But we are going to place you under oath so we know that your answers are truthful. If you could please raise your right hand and take the oath of witness. Mr. Gaynor.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I did. Thank you. Dr. Wade, you heard me mention that. If I don't look this way, you don't see.
All right, look. Why does this doctor's profile picture go as hard as it does? This doctor's profile picture should not go as hard as it should.
See my face. I'm gonna look to the side so I can see you. Can you tell us a little bit, please, about your educational background and professional training?
So my name is Elliot Wade. I am a licensed physician in the state of Nevada, amongst other states. I went to medical school at Emory University in Atlanta, Georgia, graduating in 2005. I completed an internal medicine residency. We finished that in 2008. I am board certified. My current title is Regional Medical Director for the Western States for NAP. Here I oversee 22 jails in 8 states, including 4 in the state of Nevada. I help, amongst things, monitor lots of patients, providers, nurses, health services administrators, help set a lot of policy in regards to lots of different things, including medical assisted treatment. I'm sorry I'm not able to be there today. I'm currently in San Diego to attend a few sessions of drug court down here and get some things done, but I think Kendra reached out sometime late last night about needing some help. This is a case that I'm aware of because, as noted, I have seen Mr. Hillygus on at least one occasion and have received a few emails from different various sources over the past few months, which have necessitated my review of his case and his care, as well as advice for the staff on site over the past several months.
Okay, thank you. And so you're aware of why we're having this hearing, are you not?
In short, from my standpoint, our health services administrator, Kendra, reached out and said that she needed help and that there was a request from the court to have somebody knowledgeable in his care to be available without getting too off topic. It was determined that it would best be for me to handle that.
Okay. The court is trying to get information from which it can make an informed decision on whether Mr. Hillygus is fit to proceed to trial beginning next Monday, or alternatively, if he has something going on which can be treated or is treatable, such that he could be ready to go in the near future. He indicated yesterday that he doesn't think he's in a position for various medical reasons to proceed with trial. The prosecution strongly objected. His co-defendant was in agreement with the request for a postponement. The court needs to make an educated decision here. And so I invite you to please summarize Mr. Hillygus's medical status, and then if you have any opinions on how that might bear on his fitness for trial, to be transported daily, to sit through 6 to 8 hours with comfort breaks for bathroom and lunch, to listen to, understand what's occurring, and to be able to pursue his defense. Those ultimately will be some of the questions based on your actual engagement with him or your review of his case file or speaking to others. So I know that's a big open-ended area, but can you please talk to those? And it looks like you've started to summarize that in the form of an email, but you can refer to that if you have it handy, or go by memory if you don't. Go right ahead, sir.
Sure, thank you, Your Honor. So I was yesterday, or I guess even this morning, I wasn't sure if virtual court was, or this Zoom platform was available to us, and so that's why I wrote that email, because I wasn't sure at the time, hey, is this going to be granted? So that was the reason I said that. In terms of his overall care, he's a 56-year-old gentleman with a history of high blood pressure, a noted traumatic brain injury, we call TBI, in the past. He'd previously been on some medication, specifically lisinopril, to control his blood pressure. However, he has chosen over several months not to take that medication, which is his right. When I saw him in March, Mr. Hillygus was correct that it was after a fall. I believe it was maybe 2 or 3 weeks prior to that. When I saw him, he was in a wheelchair, and most of his that interaction was about getting a supplement called triple magnesium, which we were able to procure for him. At that visit, he had noted some numbness in his toes, his feet, and his low back pain. And he noted, quote, coldness in his upper extremities with some color change. Given that complaint, I determined that it wasn't appropriate to try to get him up and try to walk him around. And really the discussion with both him as well as the staff was to get x-rays of his, Kendra referred to as C7, but that C stands for cervical. So to get x-rays of his cervical, thoracic, and lumbar spine. Those x-rays ended up showing no fracture, but did show that he was having some muscle spasm. Mr. Hillygus had noted a condition called a neurogenic bladder, where the bladder doesn't truly respond to sort of normal stimuli. It was his belief that the triple magnesium would help that condition, as well as his condition in regards to his bowel control. After I saw
bowel
him
control
in May of this year, he asked for an ADA, or Americans with Disability Act, shower chair. In July, there was a note sent that ended up coming to me that he felt that being incarcerated was detrimental, deteriorating, and declining effect on his physical and mental capabilities. The provider at that time allowed him to have a snack and some Gatorade with the thought that maybe that would help. Within a week, I think about 8 days, he noticed some chest pain radiating to his right arm, and on July 25th, he was sent to the hospital, given that concern. He was returned from the hospital that same day, determined not to need admission to the hospital or have any other condition or abnormality that was preventing incarceration or needing referral to a specialist. In review of his labs from that ER visit, it noted that his kidney function was consistent with chronic kidney disease stage 2, which shows a mildly reduced function, which is actually fairly typical for somebody with high blood pressure. And generally speaking, the recommendation would be to treat the blood pressure to not have any further compromised kidney function. Interestingly enough, the medication that he was on previously, like lisinopril, would actually be really good to help prevent any further damage to the kidney. Again, this damage is long-term, it's not an acute thing. Since that time, he noted to the staff that he felt that.
So, real quick, guys, I want to note that I'm probably going to stop the stream before 8 o'clock. Because I'm probably going to be watching the live stream with Dummy Kruger, KFAR, and Kick on BSBT's body cam arrest body cam footage. So just give you guys a heads up. Wait, do I have a redirect for that? Hold on, I gotta set that up.
He would benefit from electrolytes.
Look, Thea, I'm already a little bit too far. I'm too buzzed to go get a Zinger Melt. I swear, I'm going to try this weekend to get off my ass and go get a Zinger Melt. I promise.
To help treat his neurogenic bladder, as far as I'm aware.
Yeah, Manny, if you could set up the redirect so that when I end the stream, everybody gets sent over to Dummy Kruger.
On that ER visit on July 25th showed that his electrolytes were normal. Certainly being hydrated water certainly helped. And as far as the wheelchair, again, as Mr. Hillygus said, I only saw him personally in March. There has not been, as far as I'm concerned, any demonstrable evidence as to why the wheelchair is needed, but I've also told the staff it's not worth arguing with him about it, just to allow him to have it, certainly to get to court. We know that he has an injury from prior to incarceration, and so just to allow for the wheelchair, I think would be fine.
Oh,
but
darn
as far
it!
as I can tell, there's no acute issue that would preclude him from attending.
Well, somebody get in touch with W. Kruger and tell him to turn on the privileges. Dingus.
I think certainly, trying to make sure that, from your standpoint, that he's comfortable while he's in court, able to get to the bathroom, that sort of thing, I think would be appropriate.
All right, what about anything that you're aware of that would, in your mind, impair his ability, other than you've already talked about, to proceed to this trial? It's currently set for 9 court days, beginning a week from yesterday, and then proceeding the following week if needed, from the Tuesday through the Friday, because we have the...
I mean, can I Uber the Zinger? Hold on.
Are you able to identify anything?
I think it's... no, I can't. I can't. The Zinger is too far away. The closest place is like about 25 minutes away. That's way too far.
The court should consider, with respect to this request, to postpone the trial.
I'm not aware of any mental health conditions that would preclude him, or any acute medical concern that would preclude him from attending court.
All right, thank you. Mr. Steggy, do you have any questions of Dr. Wade?
No, thank you.
Mr. Silverberg, do you have any questions of Dr. Wade?
Just briefly, have you looked at any of Mr. Hillygus' medical records over the last 2 to 3 weeks?
Yes, I have.
And what did you learn there?
I don't think anything different than what I just reported.
What were
Brew would work. I probably need to get arrested.
Electronic medical record system.
Is it just internal?
In the last 2 to 3 weeks, yes. He hasn't been he hasn't been outside the facility to any other medical provider.
Thank you.
Mr. Hillygus, any questions of Dr. Wade?
I do have questions, but I'd like to object that I've never been prescribed lisinopril for high blood pressure. That was prescribed, or that was ordered by NAFCare to be given to me, and I refused to take lisinopril because I've never been prescribed lisinopril for high blood pressure. I just wanted to clarify that.
Okay.
Okay, Dr. Wade, at whose request are you appearing today?
The courts.
Okay, so you had ex parte communication with the court prior to this hearing?
He didn't say that.
He said the courts.
The court issued an order that was given to all counsel, to yourself, and to a copy to the sheriff.
I know you're employed by NAFCARE, but I did not hear how long you've been employed with NAFCARE, I don't believe.
5 years.
Look, all right, look, I'm not going to Uber Eats the Zinger, all right? If I'm going to try the Zinger, I'm going to try it fresh, all right? All right? All right. Good talk. God!
RA just donated 100. They said Zinger delivery tip.
Thank you, RA, for the $100 tip. $100 tip. Welcome, Raiders.
I was a hospitalist for 10 years.
We're just watching
hospitals in Nevada and throughout the
a soft sit pre-trial hearing. Welcome, everybody.
Can I address
everybody? Shout out to Big N
to say something else
for his awesomeness.
Thank you.
The dude does good work.
You sworn a Hippocratic oath to do no harm.
I appreciate it. Thank you, Big N. Hey, welcome, man. How you doing?
I would challenge the word swore and what that means.
If you ask him if he's taken the Hippocratic oath, maybe that's...
Have you taken a Hippocratic oath to do no harm?
At the time of granting the Hippocratic oath, which are questionable.
Is it your practice?
By the way, I'll just comment on that. The court...
So, all right, let me break it down for the new guys. Welcome, Raiders. I appreciate you guys being here. We are in a pretrial hearing for a soft sit. He is alleged to have kidnapped his own mother from Nevada to California, hooked up, and we are now at a hearing to determine whether or not the trial needs to be continued due to the soft sit's supposed health complications. He is now cross-examining the lead physician in for the county jail. And so that's what he's doing right now. Also, yes, guys, if you like what you see, please hit that sub button. I'm like 25 subs away from 15,000. I'm almost there. I'd really appreciate it. Thank you.
Interestingly, read an article about how different states...
Yes, he kidnapped his own mother.
They're moving to a more holistic oath or allegiance to newly admitted physicians. So, Doctor, it's not lost on the court that there's been some discussion on what type of oath or what type of allegiance to be identified. But
thank you, Cerebral, for the $5.
So that's not directly relevant to the court's inquiry, but I'll let you ask a few more questions.
Is it your practice to help your patients?
Generally speaking, yes.
Is Mr. Hillygus currently your patient?
I believe so.
You admitted to evaluating him one time in March and not seeing him since, so please explain how...
So are you talking about yourself in the third person, or you're talking about yourself? Right, go ahead.
You've admitted to seeing Mr. Hillygus once in March. Have you seen him since then?
Welcome, Raiders.
Not including today.
Well, you've seen me here, but have you treated me since March?
I have been asked about your care from providers who are on site, so I believe that would be yes, even though I would admit that is not direct patient care.
So you've not had direct patient care with Mr. Hillygus, is that correct?
Not since that visit in March.
Okay.
Have you discussed and reviewed with Mr. Hillygus' extent?
I forgot. I don't have the subs on. Hold on. I'm sorry.
Medical history, and what are your findings?
Well, that's too broad of a question. I just had him go over. He's already testified generally to your current status and some of his findings. Can you be more specific? What's the point you're trying to establish to the court here? I guess we can focus your question.
That other than the one time that we've discussed and reviewed my medical history, have you done that since then?
Again, I've met with you in March that one time. Since that visit, you've been seen by providers on site who often have asked me my opinion or what they think or what I think they should do as far as next steps.
Can you explain to the court who are the licensed providers with the medical board at the Washoe County Detention Facility currently employed by NAFCARE?
Yeah, I mean, to the extent you know that, that's pretty broad. He said he oversees several different facilities, if I understood correctly. So I'm not expecting him to roll off his tongue a list of people.
Well, he should know who the medical providers are at Washoe County. This is about me, and this is about today's hearing.
The court would disagree on that point, Mr. Hillygus, but
Okay, look, if he's the director of like the entire, my understanding based on his initial credentials is that he's in charge of the entire system for all the prisons in Nevada. I think it's fair to say that he can't be expected to know every single practitioner who is assigned to every single jail, including the county jail.
But Dr. Wade, do you know any of the specific licensed medical practitioners that office out of the Washington County Jail or have been involved in Mr. Hillygus' care?
Sure. Our medical director at Washoe is Dr. Joseph Benson. Our provider is Rex Weeks. He's a physician assistant. He actually has his physician assistant license under me as I'm his
13 subs
physician,
away from 15,000.
Reaches out to me directly
Yay.
About when he has questions. Formerly, we had Billy Botany, without getting too off topic. Her last day was yesterday. And then I'm not sure if there's a reference to the mental health providers that are there, but there's a Dr. David Fennell. He is a psychiatrist. We have Dr. I'm probably butchering her last name. You can correct me if I'm wrong in the record. Dr. Yassar, Y-A-S-A-R. She is another psychiatrist. And then I believe we have a few other mental health professionals, but I'm not sure, and nurses, but I'm not sure he's referring to all of those people.
Thank you. Has Dr. Benson evaluated myself?
12 away. 12
I'm
away
not
from
entirely sure
15K.
when I sit here. He may have seen me one time, but I'm honestly not sure without looking at the record.
As the medical director.
Do I have a lot? Really?
Normally
Sally, do I
required
actually do have a lot of ads? I'm sorry. Hold on. I can adjust that, though. I didn't realize
Everybody that's an incarcerated individual.
I was pumping out a lot of ads. I apologize.
Depending on the day of the week, it can depend if Dr. Benson has the bandwidth to see patients individually. I think in this particular case, given the complexity of it, as well as, again, since I'm Rex Weeks' direct supervising physician, I think it's been fine to defer to me on this. Just go ahead.
Thank you. Has Mr. Hillygus been treated by the mental health professionals in the facility?
Joshua, thank you for the 5 gifted memberships. I appreciate it.
Mental health providers, and I cannot recall if you've been seen by the mental health professionals.
Wazoo! Thank you for the 10 gifted memberships.
Allow a couple more questions.
10 gifted memberships. Both of y'all. Thank you.
I've got quite a few more questions. This hearing was regarding me, and I have quite a few questions that I'd like to ask of Dr. Wade. I know the court has weighed in and taken some of the time away from me, so I would object to ending the hearing without me being allowed to defend myself and to...
Deacon! Oh my God. Deacon, thank you for the 10 gifted memberships.
Inquiry here, right?
Physicians that are supposedly treating me, that aren't treating me, that aren't physicians, that aren't prescribing.
Wow. All you new people getting some memberships there.
It's admitted that this doctor saw me one time in March, and he hasn't seen me since.
Well, you can make argument as to how the court should interpret his testimony, but I want to find out what he has to say, and then we're going to let him go on to do other things, and I'll hear from you and counsel on what the court should do.
Are you certified or authorized to prescribe controlled substances?
In general, or specifically in the state or in the jail?
In the state and the jail generally.
Yes, I have 3 DEA licenses in the state of Nevada.
Have you prescribed, thank you, have you prescribed needed medications for injuries Mr. Hillygus sustained while detained in Washoe County Detention Facility?
I don't remember when I saw you in March if I prescribed you medication or if you were already on those medications and therefore there wasn't a need for a duplication of those prescriptions.
Have you approved and scheduled a hospital treatment for Mr. Hillygus?
In the past, or you mean upcoming?
Upcoming. Have you approved or scheduled an upcoming hospital treatment for Mr. Hillygus?
No.
Do you know who did?
Well, let's start.
It was admitted by Kendra earlier that there's been a scheduled appointment with the hospital for an evaluation.
For physical therapy? Is that what you're talking about, Mr. Hillygus, for possible physical therapy?
And other issues.
Okay.
As far as I'm aware, there is a physical therapy appointment that is scheduled. I don't know if it's at the hospital, so I would not say on the record that you have something scheduled at the hospital. I just want to be clear about that.
Did you recently treat
How
Mr.
close am
Hilligus
I?
for heat stroke or heat exhaustion?
No, I did not.
Is heat stroke or heat exhaustion a serious medical emergency?
Oh my god, I'm 6 subs away from 15,000.
Can and do people die from heat stroke and heat exhaustion?
Yes.
Is medical
Appreciate it,
hospital
guys.
transport and IV therapy standard operating procedures for medical emergencies?
No.
Were either of these treatments offered or considered for Mr. Hilligus as a medical emergency?
Well, that's, hold on.
Do you
No,
know?
hold on. That assumes a fact, right? That what you went through was deemed a medical emergency by somebody. But can you rephrase that question? Because that's.
Do you know?
Hold on, Mr. Hilligus, let me finish talking. That has some assumptions baked into it, so I'm gonna make sure this is a fair question to the physician. Go ahead.
Do you know if either of these treatments were offered or considered for Mr. Hilligus during his medical emergency?
So again, if to the extent you can answer that, Dr. Wade, you've already heard the court's concerned with the use of the term medical emergency. I'm not questioning that Mr. Hilligus believes he was suffering a medical incident. He's made it clear that he did. But to the extent you can answer that question, go ahead, sir.
I would say that, to your point, Your Honor, that the incident was determined not to be a medical emergency and therefore did not require IV fluids nor transportation to the hospital.
What was he transported to the infirmary?
That I'm not sure. I would need to open the medical record.
Would there be video of that transport?
Considering there's video throughout the facility, I think in every location other than bathrooms, I would think that there is, but that would be a question better directed to custody as to whether or not that there's video about that.
Were his vital signs taken in the infirmary and were they normal or abnormal?
I would need to review the medical record, but I would surmise that they were determined to be acceptable.
Was Mr. Hilligus dehydrated? Was he treated for dehydration?
Oh my god.
I suppose the question would be whether on what day is that question referring to, because I believe there's been more than one complaint about dehydration on different days.
On the day that he was transported to the infirmary for the heat exhaustion?
I don't believe that anybody determined that there was indeed heat exhaustion, one, and then two, I would need to look at the actual date in question.
Through the video, can it be determined that Mr. Hilligus was exhibiting involuntary shaking and convulsions?
So that's, again, got a question, got some assumptions baked into it. We're asking to assume that there's video of your status, and if he had seen it, could it possibly have shown you to have those symptoms? That's speculation right now.
Are there video cameras in the infirmary?
I believe there are, yes.
So would there be video of Mr. Hilligus involuntarily shaking and convulsing while being treated for heat exhaustion?
So again, I don't know, one, that it was heat exhaustion, and two, if I were to see video.
Thank you, Thomas, for the 27 months.
Reasons why somebody could be shaking, some which are medical and some which are not, and I don't believe that by a video by itself you'd be able to determine that.
Was Mr. Hilligus prescribed Keppra?
Okay, I don't know. Well, I do know why Hillygus is talking to the third person. This is a standard soft-sit tactic of trying to separate themselves from their corporate fiction entity, or dead fiction, whatever the hell they call it these days. So I'm not surprised he's talking about himself in the third person.
You mean that recently, as a result of coming in?
Be right back.
On the day of the incident we're discussing.
Okay. Do you know the answer to that, Dr. Ray?
I believe Rex was concerned about the possibility of a seizure, but I don't remember if he prescribed Keppra. The generic name for that is levetiracetam. As I sit here, I don't know that, so again, I would need to review the record as to whether or not that was written to be able to answer that. It honestly wouldn't make any medical sense to me as to write that medication.
What is Keppra specifically prescribed for?
Typically, it's for anti-seizure.
Was Mr. Hilligus prescribed muscle relaxers
numbers
to support the stiffness from a seizure?
Raining.
That would be inappropriate prescribing, but muscle relaxants can be used for patients.
Was Mr. Hilligus exhibiting a stiff neck and stiff jaw, a classic symptom of a side effect from a seizure?
I would counter against that as a classic finding of a seizure. But yes, a muscle relaxant has been prescribed for you.
Can a seizure be triggered by dehydration and low blood sugar?
In theory, yes.
Has Mr. Hillygus been prescribed electrolytes for dehydration?
Electrolytes wouldn't be for dehydration.
Has Mr. Hillygus been prescribed hydration supplements for additional hydration needs?
I believe that Rex did write for Gatorade.
My God, everybody's gifting memberships. Satale, thank you for the 10 gifted memberships. Aerial Scout, thank you for the 5.
For a natural approach to health care, do you know?
I'm fairly certain that would be a yes. I believe he met with a physician in Dallas, Texas, and that was kind of where the genesis of the request for a triple magnesium supplement came. That he felt that triple magnesium was beneficial to treat blood pressure, neurogenic bladder, and sorry, I'm blanking out, but a concern issue with his bowels.
Does it appear Mr. Hillygus is attempting to receive his prescribed controlled substances for nefarious purposes?
From memory, I don't remember that there was a controlled substance that you were on prior to incarceration. I believe that the pharmacy review, it's a system we call SureScript. I believe that was negative.
Thank you.
And again, I think the conversation that I had with you in March was that you prefer natural supplements, so I would think that a controlled substance would not be natural, therefore wouldn't be a part of it.
Is Keppra and Robaxin, are those controlled substances?
Keppra is not a controlled substance. Robaxin, it might be a controlled 5 substance. That's one of those
More away from 15.
Robaxin might be, like on the very lower level, but not in the same category. So sorry for background, there are different levels of controlled substances, 1 through 5, 1 being no medical therapeutic benefits, so things like fentanyl. Sorry, fentanyl is actually Schedule 2. Something like carfentanil or xylazine, the stuff you see on the news, that's a Schedule 1, and then low-level things like tramadol, cough syrup with codeine might be level 5, and so I believe Robaxin might be in that Schedule 5 category.
Does Mr. Hillygus follow the rules for taking his prescribed medications?
Outside of the lisinopril that was written for and refused, as far as I'm aware, the prescriptions for the magnesium and the multivitamin and the muscle relaxant, you have been consistent with taking those.
Deacon, thank you for the 5 gifted memberships.
Yes.
Is Mr. Hillygus currently housed in the infirmary?
Ooh, I would defer to Kendra on that. I see the housing in the chart, but I don't remember what all the codes refer to.
Is the infirmary an ideal housing option for Mr. Hillygus? Why or why not?
Okay, you don't have to answer that. That doesn't inform the court's decision here.
Well, it does, because I am in the infirmary, and I'm in solitary confinement. I'm being isolated in the infirmary. And the infirmary is
Oh,
not
shut the hell up,
for
Hillygus.
somebody that's trying to defend themselves, because you have inmates that are being forced medicated. You've got inmates that are smearing feces on the doors and the windows of their cells. You got inmates kicking and screaming and yelling all day long. It's sleep deprivation, and it's not an ideal place. I don't have a table or a chair to be able to work on my discovery and to be able to work on this case. And being housed in the infirmary is depriving me of the ability and my due process to defend myself in this case.
All right. Let me ask you, I'm going to let you ask 3 more questions of Dr. Wade that you think will inform the court, and then I'm going to excuse him, and I'll hear argument like what you just made, if you believe that bears on your ability to proceed to trial. Go ahead, Mr. Hillygus.
Did you want me to answer that last question about the infirmary?
Sure.
I think that is one of the harder things about taking care of incarcerated individuals, trying to balance their medical needs and the attention that we on the medical side give with the downsides, as you noted, that occur in the infirmary. So that infirmary or medical housing area.
Thank you, RA, for the $100 tip, you crazy bastard. What the hell? Thank you. You want to donate? There should be a $sign at the bottom of the chat or tip. Thank you so much. Let me see where I'm at now. All right, I got 3 left. 3 to go, according to my studio.
Area certainly is, from our perspective on the medical side, that puts you as close as possible to the medical staff, so that effectively, I believe the furthest room from the position where the charge nurse sits on that unit, I believe the furthest unit is, the furthest cell might be like 50 feet. That might be a little bit too far. And so the benefit again is being close to medical, so that if you need something,
well, probably
able to be, respond as quickly as possible.
You put me over the top.
Spot in the jail. The downside, as you noted, is that there are a lot of patients with mental health disorders. That's I guess a whole other thing in terms of just what ends up in the jail with having a lot of people who have mental illness, and it's our patients that have the most serious mental illness are in that unit, so people who are really in distress. And so, like I said, it's the hard part of trying to find the balance of your medical needs while being in a unit that's tough for everyone. I think
tacos are going to win tonight.
We certainly have patients where they said, you know what, Doc, I hear you, I know that you're concerned about me, but please get me out of this unit. And sometimes it's not shared that nicely, said in more terse terms. But certainly, if you don't feel that you should be on that unit, and you think that you would benefit from being in another unit, then that might be worth discussing with custody and maybe having a meeting with custody and Kendra to discuss, hey, yeah, I know you guys are worried about me, but for my own mental health, for my own sanity, for my own peace, I think I'd be better served by being on a different unit. And I think that's something that could be discussed.
Thank you. Do prescribed and controlled substances that Mr. Hillygus has been prescribed, do they come with side effects?
Well, you already heard him say he's not aware of any controlled substances.
He actually said that he is aware that I'm taking Robaxin as a level 5 controlled substance. So
hold on, Mr. Hillygus, hold on. So,
side effects.
Okay. So Dr. Wade, did you hear the question?
Yes, I did, Your Honor.
All right, what's the answer, please?
I think, in general, unfortunately, every medication on the face of the earth has side effects. Certainly, the magnesium is a side effect, even though it's natural. Having personally taken
One away.
You take it on an empty stomach. For some people,
one more to go.
It can cause an upset stomach. Robaxin.
14,999
with that medication, which is generally why it's written for at night.
Thank you. Do controlled substances come with warnings?
So, Mr.
It's also from a pharmacy.
I know, Mr. Hillygus said you're
side effects and warnings.
The court can take judicial notice of the fact that they come with warnings.
Well, this isn't, okay, well, so they come with warnings.
Yeah, the witness is on Zoom.
To operate heavy equipment or drive a car or to enter into legal contracts or attempt to defend yourself in a court while impaired.
Did you hear? Is that the standard? You're asking if that's a standard warning?
I'm asking if there are standard warnings that come with narcotics and controlled substance not to operate heavy equipment or to drive a car or to enter into legal contracts or attempt to defend yourself in a court while impaired.
You're asking if that's the federal...
Oh, this guy being a skeezy, MFer. Okay, I'm trying to curse. So oh my God, he's trying to, what? He's trying to do a mistrial? He's trying to pull a mistrial. That's saying like, oh, I'm representing myself, but because I'm on some sort of narcotics, I'm not allowed to defend myself in court. Oh, what? Oh, that's irritating.
I'm asking him if there are warnings to this effect with medications that are prescribed by the pharmacy.
Oh, yay, I made it, 15K. I got it. Thank you, Thomas, for the gifted membership. 15,003. I made it. Thank you, guys. Never thought I'd make it to 15K. Thank you, Deacon. And thank you, Mandy.
Again, the court can take judicial notice that with certain controlled substances, there are warnings and limitations on what the person taking the medication should or should not do when we're using that medicine.
I'm asking the doctor the question.
I know, but you're
not
trying
a
to-
physician.
You're trying
You're
to.
not a pharmacologist.
Can I invite the court to use its influence to maintain order with the defendant?
I understand. We're
I've
arm
got just a
wrestling.
few more
We're arm
questions. I
wrestling.
know you said that.
So here's what's going to happen. Mr. Hillygus, this will be your last question to Dr. Wade, then we're going to excuse him. The court understands what he's testified to from all the questions from the court,
Thanks,
counsel,
guys.
and yourself, and then I'll hear
I
argument.
appreciate
Go
it.
ahead, Mr. Hillygus.
In your professional opinion, can you state that Mr. Hillygus would benefit from a continuance in this case?
Never
until
thought
after
I'd
he
make
can
it
receive
to
therapy, be
15K.
housed in other than the infirmary and be reevaluated for the substances that he is currently taking, which have side effects?
Are you able to answer that question, sir?
Your Honor, I had a question, I was unsure if I was supposed to answer the previous question or not.
Let's focus on this one.
Okay, Mr. Hillygus, could you ask that again, please? I'm sorry, I thought there were 3 parts to it.
Yes, there are. In your professional opinion, would myself
Really, John?
benefit from a continuance in this case until after I can receive the approved and scheduled therapy, be housed in other than the infirmary, where
Thank you,
and
Cerebral.
admitted that's not an ideal
For the
location,
15.
and
Thank
be
you very much.
reevaluated for the substances that I'm currently prescribed and taking.
I'm not doing a hot tub party.
The compound nature of the question and the speculative nature of it.
No, it's
That's only on my
Hold
OnlyFans.
Hold on. I'm going to let the doctor answer to the best of his ability. Dr. Wade, if you can answer all or parts of that, please do so.
So, Your Honor, I'm not, since I'm not a legal person, I'm not sure what continuance means.
It means a postponement. It means a
Yeah, I was
postponement.
gonna say, okay. I was gonna say, my layperson, interpretation was to push it off.
Yeah.
I did say that. If I would ever hit 20K, I would shave this all off. That is true.
I think, again, moving a unit could be discussed, I think possibly even today. And I'm not sure what reevaluation would do in terms of changing the thought today about being able to proceed with the court proceedings. Certainly, I do this, not coming to court a ton, but having had plenty of patients in 5 years in custody, even including today for another patient that is incarcerated at Washoe County Sheriff's Office. There's certainly times where I look at it and I'm like, this person shouldn't be in jail. This isn't the right place. I think their medical condition is so extreme that they need to concentrate on that. And that's not the sense that I get with the case or care for Mr. Hillygus.
Dr. Wade, thank you for your time. The court will note that Mr. Hillygus had more questions and he would object to the court ending Dr. Wade's testimony, but nevertheless, the court finds that he served the purpose that the court directed a representative to be here today for. Dr. Wade, you can drop off the call. Thank you for your testimony. Wish you a pleasant afternoon.
All right, thank you, sir.
Thank you. I want to remind us all that yesterday I indicated to Mr. Hillygus that if he wanted the court to consider appointing counsel on his behalf to represent his interests with respect to medical issues, the court would consider it. And Mr. Hillygus politely but firmly refused that.
He did refuse.
And said he's prepared to advance this on his own. So I just want to remind everybody of that. So
I would object.
So hold on.
I would object.
Please don't talk over the court, Mr. Hillygus. I'll give you a chance in a moment to be heard on what we've done here today. And with the court's comment. Mr. Stady, what have we learned and what do you ask for the court to do with respect to the oral request to postpone this trial?
It's the defendant's motion, right?
Well, I want to hear from the state.
Rule 15 requires good cause, it also requires an affidavit.
Thank you, Sathail, for the...
Sathail just donated 100. They said 15K. Woo.
Thank you, Sathail, for... Oh, my God. Oh, my God. Thank you, Sathail, for the $100. And thank you, Rob, for the 1337. Congrats on 15K. Onward to 20K. Thank you very much. Yes, Stilla, I do jump scares at $100 a pop. I used to have them much lower, but viewers of mine took advantage of that profusely, and I had to raise the price. But thank you very much, guys. Yes, we're about like 6 minutes away from Dummy Kruger about to go live, so we're gonna see if I can skip through this.
Today what happened is the court ran his motion for a continuance for him. He's made no case for it. Every witness today...
Thank you, guys. I appreciate it.
Anything about being left outside or about his proceeding the trial, a resounding answer is there is none.
Why do you say that?
Oh, there's no evidence for it. He has no chronic conditions that would prevent him from going forward. He has no mental health issues that prevent that.
That's usually what happens,
his
Sarah.
daily care. His daily medical care is rather benign, right? Low level. He is a high maintenance by his own, and I asked the court to reflect on what we learned from the evaluations related to competency. There's no barrier to competency. As a personality feature, he's a hard person to get along with. He's demanding of the medical. In the entire time he's been in, there's no psychological or the mental health that would lead to good cause, right? Good cause because he's too sick, doesn't feel well. He hasn't even made a case. His own motion was really nothing. And today, everything we learned about Mr. Hillygus was not
Very quiet for you guys. All right.
More about his ability to prepare, etc. But he hasn't made the case. I'm not going to make that the most important, but I'll say the man has had many years to prepare for this trial date, and it is I think it's obvious as it gets closer, his own anxiety leads him to attempt these delays. The court should also reflect on the GR and PR cases that are the foundation for this case in which the defendant was found to be vexatious because of his repeated delay tactics, repeated and numerous delay tactics. If the court were to summarize in one word, is there anything wrong with the defendant that prevents him from going to trial?
I'll hear from you then. Mr.
Thank you, Aereo Scout.
Once again, I object to this hearing completely, as I've not been provided a witness list. There's been no evidence submitted in this case. There's been no emails that have been ordered to be provided for my grievances. There's been no provider present that's personally evaluated me, with the exception of Kendra, who said she took my vitals one time. I have legitimate injuries. This is
the problem is I can't raise the volume of the TTS without also raising the alert volume for you guys. I can't do that. That's the unfortunate reality.
I've not, like I said, I've not been provided any evidence for today's hearing. And for Mr. Stady to bring up the civil case, I want everything stricken because that's bias, talking about a vexatious litigant in a civil case. This has no bearing on this criminal case. And by doing that, it's creating a bias against me. If I dissolve the civil case, which it is, then it's a civil case. There should have been an order. I did not kidnap my mother. She wanted to leave. She requested to leave.
Oh,
She was
boy.
a resident, not a patient. She had the right to vote.
Mr. Hillygus.
All right.
So if
I don't want to
we're
talk about it
talking
right now.
clear, then it is a civil case.
Let's be clear.
Thank you for the 7 months.
Reference Mr.
Appreciate it, man.
Stady was to the PR case, that's a probate, and to the guardianship case,
It's a civil case.
to two non-criminal justice cases. But this
All right.
decision on whether this case goes forward will not turn on the court's understanding of what happened in those proceedings.
All right, I gotta stop it. We're about 2 minutes away. All right, I'm gonna stop the stream, guys. I'm putting the link in. This is the link to DK's live stream. Everybody go check him out. I'm gonna be there. Use the hashtag ArtyRaid, and we're gonna sit back, relax, and enjoy the body cam footage of BSBT getting hooked up yet again. But here's the link again. I'm gonna spam the link for you guys to check it out. Thank you guys. I appreciate it. Thank you so much for the congrats for the 15K. Never thought I'd actually get there from live streaming. I didn't start doing this until like like December 2015. So took me a while, but here I am. All right. Thanks, guys. Have a good one, and I'll see you next time. All right. Link again. Adios.